The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have 4 interesting cases, good lawyers, and we're looking forward to the arguments. In the first case, United States of America versus Brooks Leshane. Ms. Tarleton?
Yes, Your Honor. Thank you. Good morning.
It's good to have you with us.
It's good to be back. Thank you. Good morning, and may it please the court. Jackie Tarleton for Brooks Leshane. Your Honors, everyone agrees that Brooks Leshane is actually innocent of his 2003 conviction for being a felon in possession of a firearm. Everyone agrees that no remedy other than quorum nobis is available to him to correct that error. And everyone agrees that this error, an illegal conviction based on actual and factual innocence, is of the most fundamental character. Although the government suggests otherwise...
Well, why do you say that it's an error of the most fundamental character?
That's so, Your Honor, because this is a conviction based on actual and factual innocence. Mr. Leshane has been followed by a conviction for an offense that he never committed. And I think we both agree about that.
Saying an offense he never committed because you say there's no offense.
That's right.
Any longer.
After Simmons, we know that the North Carolina convictions that served as the predicate for his felon in possession conviction are not, in fact, felonies, as this court determined in Simmons. So in 2000...
Well, but then it wasn't just Simmons. It was Miller.
That's right. Miller is what made Simmons retroactive.
You have 2 fans on this panel of Miller.
I'm glad to hear it.
You got one author.
I wrote it.
That's right. And I think, Your Honor, there is another opinion that you've authored in Adams that I think is relevant here. There's some talk from the government about adverse consequences and whether Mr. Leshane has suffered sufficient adverse consequences to require this court to grant quorum nobis.
Well, is it true that if we give you the relief, the sentence is still going to be 156 months? And if that's true, what are the other collateral consequences?
I think if Your Honor is referring to the 2019 conviction, this court, another panel of this court, has already dismissed that case, so the appeal is not pending. His sentence would not change. But
that was dismissed on a appeal waiver.
That's correct.
They didn't address the legal issues.
They did not.
Was he adversely impacted by this 2003 conviction in the sentencing in 2019?
I believe so, Your Honor. And the reason I say that is because even though he was deemed to be a career offender, and so his felon in possession conviction did not affect the calculation of his guideline range, the offense was still scored 3 points. It still appeared in his pre-sentence report. It still was something that the court was not only allowed to, but in fact bound to consider under 3553A. Mm-hmm. So I think, this court's decisions in Mandel, the Supreme Court's decision...
Is Mandel, you think, is your best case?
I think Akinsade is our best case.
Which one?
Akinsade? I hope I'm pronouncing
I was on that, I think.
I'm sorry?
Was I on that? Was that Judge Traxler's case one?
I believe that Chief Judge Gregory...
Judge Gregory. Maybe Judge Traxler just said it. Yeah.
In Akinsade, the petitioner didn't file a quorum nobis petition.
Let me back up a minute here.
Yes.
They've talked about these 4 prongs.
Yes.
You're talking about these 4 prongs. When the Mandel case came down, those 4 prongs had not been identified.
Mandel started the ball rolling.
Isn't that right?
Would be, yes.
But so Judge Widener, who authored the majority opinion in Mandel, didn't have to walk through the 4-part test. Did he, in substance, cover the 4-part test, you think?
I think so, and I think, I've not seen a decision where this court has denied quorum nobis relief on the basis that there were no adverse consequences from an illegal conviction. I haven't found that case, and I think that's significant.
Well, one of them was a disbarment, which is pretty serious for a lawyer.
Sure.
And what was the other one?
There was one that dealt with the risk of deportation.
Deportation, that's pretty serious too. Is this situation for your fellow measure up to that?
I think this court and the Supreme Court's decisions in the concurrent sentence doctrine are informative here, because the question is, if we're not dealing with the initial sort of felony label or felon label, if this is a second felony conviction for someone, is it still sufficiently adverse to satisfy Article 3? Article 3 is a pretty low bar in terms of having a case or controversy. And in Ball, the Supreme Court said there's adverse consequences even of a second felony conviction because it can delay someone's parole eligibility. It can result in an increased sentence under a recidivist statute for a future.
But those are speculative, aren't they?
The Supreme Court didn't think so.
All right.
The Supreme Court thought that.
Have you got anything that's not speculative for your man?
I think looking at the 2019 case is a perfect example. When you look at the pre-sentence report that was filed in that case.
When was it he got that $200 assessment?
He paid a $100 special assessment for the 2003 conviction, if that's what you're referring to. So
Well,
I believe that
I
under
thought
Rutledge.
I thought there was a $200 assessment or somewhere. So he paid it?
He did pay it for his 2003 conviction, and that's another adverse
So
consequence.
government owes him $200?
It owes him at least $100.
$100, I mean, plus
2003
interest or
conviction.
something, maybe.
And I think Rutledge is supportive of that proposition.
But Judge Widener said, I'm talking about Mandel, and that's one that you all think's the best case for you. I believe that's what you argue. That's what was argued in the lower court anyway. But he's got some language in dealing with this third prong. He doesn't talk the third prong, this collateral consequences or whatever it is, being branded as criminals. I think that's a quote as being enough. Is that dicta or an aside, or is that anything we can rely on? If you're branded as a criminal, does that satisfy prong 3 of this 4-part test?
Absolutely. And I think Ball and Rutledge make plain that it's not just that first felony conviction that carries such adverse consequences. It's any felony conviction, even if someone remains a felon, as Mr. Lesane would. So I think this court absolutely should correct this error. And I want to talk to...
And we're only talking about the 2003 conviction, right? That's what we're dealing with here.
That's all we've challenged. Yes, sir.
And it's the you had 2003 conviction. He didn't complain about it. And then you had the Simmons case in 2011. Then you had the Miller case that made Simmons retroactive in 2013. And he didn't do anything about it. So for several years. So the government claims it's out of time. And the district judge said it's out of time. He just waited too long. So we've been talking about these adverse consequences, but how do you get around? Those are the two big, your problems are the consequences and the timeliness, right? Prejudice and timeliness.
Those are the arguments the
So
government...
how do you get past the timeliness?
As far as...
You wait forever on a quorum nobis?
Well, I think it's important to recognize the standard for quorum nobis. There is no statute of limitations, unlike in 2255. And there's not even a requirement that someone file a quorum nobis petition at the earliest possible opportunity. They must simply give sound or valid reasons at the time that they do file their quorum nobis petition for not filing it sooner. Importantly, the government has pointed to no adverse consequences that it has suffered as a result of any delay in Mr. Lesane's filing. And in a situation like this, I don't know why this court wouldn't correct the error when it would simply correct the factual record of Mr. Lesane's criminal history for any future purposes for which it may be relevant.
So the remedy you're seeking here today is to have this removed.
Yes, sir.
And it seems to me, because maybe I'm having a hard time, I'm seeing this a little, not differently, but wondering what's going on here. From your client's perspective, the government alleges, and it's probably true, he could have obtained this relief much earlier. That true?
Could he have filed a quorum nobis petition earlier? Certainly.
Could he have obtained a relief based upon the Simmons and Miller cases earlier?
I believe after 2013 he could have, yes.
So it would seem to me he would have benefited tremendously from 2013 to now to not have that on his record. So he's the one who suffered the detriment by not getting a benefit to which he is entitled to. So now you come later on, would that everybody would not take the benefit and just, if you're entitled, for instance, it's like being entitled to be out of prison in a different type of case. He said, well, I'll just stay here in prison and seek the relief later on down the road, or I just don't do it. And then you come and say, okay, I want relief from prison. Well, you spent time in. Well, here's an individual who's had something on his record should never have been up there, should not have been up there, but it's been lingering up there for 7 years. And now the complaint is, well, you can't have it now because you waited too long to ask for it because of our rules of timeliness. The court says, well, you got to be timely. What's the harm? I'm trying to figure out, what is the big deal? Why don't you just take it off the record?
It's a great question, Your Honor.
I mean, it's not a great question. It's a common sense question. We are not courts that have rules just for the sake of rules. I mean, we need rules and to make things work. But here's an instance, it just doesn't make any sense. It seems like to me the most judicially economical thing to do, someone comes and says, I'm entitled to this. And you said, yeah, you absolutely were entitled to this back in 2013. You waited too long to ask for it. Now we're not going to take it off your record. It's going to be up there forever. Why wouldn't you just take it off the record? I'm really miffed at that. I mean, we can talk about all the effect of the cases and what the coram nobis does, and I mean, we can wax eloquently on that, which we do in cases when we're dealing with criminals and poor people. We do it all the time. But then we get other cases, and all of a sudden, the light opens up, and we can give them relief because we make it look like it just is common sense. We should do this. So that's where I am. I just don't get it. I mean, it's an interesting case, but maybe the government, I know you hear me asking this, and I'm not asking it in jest. It's a sensible thing. What is the big deal here? Why not just do it? One stroke of the pen, done. You wouldn't be standing in this court. We wouldn't be dealing with it. It'd be off his record. And nobody's harmed. No government is harmed, nothing else is harmed.
I think that's exactly right, Your Honor. And I would just add a very minor point.
But what's all the other discussion about? I mean, we've been having this wonderful discussion about all these cases and what they mean. The end result is, why do we waste our time on these kind of cases? There are far more important issues to deal with than something where an individual is entitled to a relief, but you don't want to give it to him because it took too long to do what? To simply come into court because of the way we now fashion it procedurally, just do it. And that's the end of it. Is there no procedure that allows for that?
I think Atkinsade allows for that, Your Honor. I think that Atkinsade dealt with the fact that a petitioner had not filed a coram nobis petition for nearly 9 years after his conviction. And the court in that opinion said that Mr. Atkinsade had, quote, no reason to challenge the conviction as his attorney's advice up to that point in time appeared accurate. And so the court did not impose a burden on a pro se petitioner to file a coram nobis at the earliest possible opportunity. It recognized the realities of the situation and said, as soon as it was apparent that this was going to cause him adverse consequences or had been causing him adverse consequences, he filed it and the court should correct it. And I think in the analogous concurrent sentence doctrine context, Judge Floyd's opinion in United States versus Adams is instructive. He said, quote, just as the criminal justice system must see the guilty convicted and sentenced to a just punishment, so too it must ferret out and vacate improper convictions. I think it's one of the most sacred duties of this court and certainly of our office that whenever we see an injustice like this one, we bring it to the court's attention, we bring it to the government's attention and do our very best to correct it, even if we can't necessarily undo all of the harms that have already accrued to our clients. Be happy to answer any of this court's questions, but I don't.
Well, how much time can you wait before you file a habeas corpus petition? Forever?
I think, Your Honor, the requirement in this court is valid.
I mean, if you say this one he didn't know it was retroactive or wasn't on constructive notice it was retroactive until 2013 when the Miller case came down. And he still didn't file for, 6 years for relief. How long could he wait? Could he wait 10 years, 20 years?
I think it's a fact-based analysis in each
30
case.
years?
I think if there were a circumstance where somehow
I'll give you all a case excuse me, I'll give you all a case nobody's seen for years, called U.S. versus Richard Nell, Nell, was decided here in 1971. The appeal was decided in 1971, but it was a quorum nobis case. And the hearing occurred in 1970, and the judge granted a writ of quorum nobis to vacate a conviction of Mann Act violation in 1932, that no relief had been sought for 38 years. In the case, though, the appeal deals with misrepresentations made by Nell's lawyer and suspension of a lawyer and contempt of a lawyer for lying to the judge. And the judge, because of the misconduct of the lawyers, actually set aside his initial writ of quorum nobis, but he granted it after 38 years. And that was in 1970. And I know something about it because I argued it. And I was the lawyer at the hearing in 1970 for the United States. Nobody cites it anymore, but it was a quorum nobis case. It wasn't anything anybody taught me in law school or anything, but I learned it by fire, I guess it was. But it was 38 years later. And I'll just throw that out there to you.
I would note also in the Ninth Circuit, Hirabayashi emerged from the same circumstance.
That was 40 years.
That's right. It was 40 years, and it was the same
From the Japanese
horror.
internment camps
Absolutely.
in World War II. And they came back 40 years later, and the Ninth Circuit gave them relief. Well, somebody would say, well, the Ninth Circuit was off the deep end maybe or something. But it was after it had been to the Supreme Court. They was following up. He was one of the litigants in the Supreme Court. They set the record right. Well, I've taken some of your extra time probably. Let's see what the government's position's going to be on this. Ms. Golden. Thank you very much, Ms. Tarleton.
Thank you. Good morning. May it please the court. Lauren Golden on behalf of the United States. This court should affirm the district court's order for two reasons. First, the district court did not abuse its discretion when it determined that the defendant failed to provide a valid reason for not attacking his conviction earlier. Second, and in the alternative, it is clear from the record that the defendant has not established adverse consequences that are sufficient to satisfy Article III's case or controversy requirement.
Now, you concede prongs 1 and 4.
Yes, Your Honor.
The government concedes. And I say you're speaking for the United States of America.
Yes, the government.
The government concedes prongs 1 and 4 of the four-part test. You contest prongs 2 and 3.
Yes, Your Honor.
Timeliness and prejudice.
Yes, Your Honor.
And the district court relied on timeliness.
Yes,
That was
Your
what you said then. And you all claimed that he should have filed for relief immediately, I guess it was, upon the rendering of the Simmons opinion. Do you abandon that position yet?
No, Your Honor, and
But Simmons wasn't retroactive on its own motion.
No, Your Honor, it was not retroactive until Miller, but I did learn in preparing for this argument that the Eastern District of North Carolina entered a standing order in October of 2011 that appointed the Federal Public Defender's Office to represent all of its clients that were currently incarcerated that may have a claim related to Simmons. And so at least in October 2011, the defendant could have potentially brought some type of post.
So you say this order that the court issued that they had to seek Simmons relief is what applies to Mr. Leshane, that he then should have filed because the local court issued some kind of an order on Simmons.
It appointed counsel for those defendants
Appointed counsel.
to help them assess whether they may have some type of post-conviction claim in light of United States v. Simmons. And there were cases where the United States consented or agreed to a Cornovus.
But you agree this fellow doesn't have an offense. That's what, right? You agree he's not There's no valid offense. There's no valid conviction.
Based on Simmons, there's no valid 18 U.S.C. 922C conviction. Yes, Your Honor.
The 2003 conviction is not an offense against the United States of America. Do you agree with that?
Yes, Your Honor.
That's what he's challenging, the 2003 conviction.
Yes, Your Honor.
So the government agrees. I'm going back to what Judge Wynn was talking to you all about. The government agrees the 2003 conviction is invalid. There's no offense.
Yes, Your Honor.
If that was the only thing he had on his record, it'd be as
Well, he
pure as a newborn baby.
had prior he had two prior.
Yeah, no, but we're only talking about the 2003 conviction. That's all he's challenging here.
Yes, that's all he's challenging.
Okay. So you're trying to show us he's a no count person. Is that relevant under any of these four prongs? And which one?
I'm sorry, I don't think I understand the question.
Well, you're talking about his other record. His other criminal convictions don't have anything, or record, to have anything to do with this. He's challenged in 2003 based on Simmons in 2011 and Miller in 2013.
Yes,
Period.
yes.
Okay.
Where in the jurisprudence of coram nobis is there any requirement or discussion about timeliness?
Your Honor, that comes from United States v. Morgan, where the court said that the defendant must show that there are sound reasons for not seeking earlier relief. And while that does not put a specific time period on when the coram nobis petition must be brought, the defendant must at least provide some type of reason to the court to explain why the defendant did not seek relief earlier. And here, looking at what the defendant argued to the district court, there is absolutely no mention as to why the defendant waited until 2020 to bring this claim. It is only on appeal that the defendant has now argued that the Federal Public Defender's Office did not have an opportunity to review his record and to assist him in bringing a Simmons claim.
Well, that sounds like you're ineffective counsel, that you're blaming it on the public defender.
Your Honor, I'm not blaming the Public Defender's Office. I want to point out that it was not until the appeal that...
So the obligation was the public defenders and not the United States of America.
No,
You're the one that convicted him.
Yes, but it is the defendant's burden under coram nobis to prove the four prerequisites and that the petition should issue and that the conviction should be vacated. And the defendant in this case offered no reasons to the district court.
But go back to Judge King's. That's interesting. He said you're the one that convicted it. The government convicts someone of something. And it turns out what the government convicted them of is not a crime. Why is it that the defendant now has to come back and say, you did something to me you shouldn't have done? And just about every other instance in our society, when you do something wrong to someone, you go and tell them. We require that in civil cases. If you got a car that's got a problem, you don't let the manufacturer says, okay, when they find out you need to come make a claim on the brakes, that sort of stuff. They make them send out notices. But here, from your perspective, once, as you said, the Eastern District took an affirmative step of calling up the public defender. I suppose on collateral review, there's not a whole lot of right to counsel that exists. So I don't know who's got a counsel who's out there with a conviction on their record even now. And yet, in the criminal context, individuals are walking around right now, just like this one, where the government convicted them of something they shouldn't have convicted them of. And yet, we have yet to put the burden on the government because they know it. You know who you've convicted. You should know. If you send someone to jail, you should know who you convicted. You should know that it's a detriment to that person to put a conviction on their record. And yet, you can do nothing. And therefore, the detriment of having that conviction continues to ride with them. And in this instance, as I said, and I'm just going back, I think you know where I'm going with that on it. What is I just don't get it. It just seems to me he's entitled to it. Everybody says he's entitled to it. The easiest thing any court can do is says, where everybody says you're entitled, you got it. Why are we going to sit here and call out every Latin term we can to show how much coram nobis law we know and use every element when the simplest thing to do is the courts have much more important and much more involved issues to deal with than this question here? How does that work? In other words, let me ask you this. Do you maintain there is no way in which this court can effectuate a relief to the defendant in this case? In other words, could he get this relief?
Based on the specific facts of this case, and it is the government's position that the court did not abuse its discretion.
So we're talking about an abuse of discretion. I'm asking, did he have the discretion
Yes.
to do it? Why wouldn't he? That's the question. He knows the government hasn't contacted this person. He knows he doesn't have a lawyer. He knows he has it on his record. Why wouldn't he exercise what sounds like to me reasonable discretion and says, okay, take it off the record?
Because the Supreme Court in Morgan stated that the defendant must demonstrate sound reasons for not seeking early.
He didn't know about it, he said. You're saying it's his fault because he didn't know about it, but the lawyers, and he had a lawyer, the federal public defender, and they didn't know about it. And the United States government had lawyers, and they didn't know about it specifically, apparently. Nobody knew about it. And so time ran, and he didn't get any relief. Let me ask you this. When the Miller case came down, was he still on pretrial or post-conviction relief of some kind? Was he under some kind of supervision?
Yes, Your Honor, and
When did that end?
I believe it ended.
I don't want to believe. I want to get it right because it's not in this record. It's not in the record. I'm asking you this because I need to supplement the record on this. And we need to know for sure.
He was convicted while in prison of misdemeanor federal charges, and he was indicted. He pled guilty to those. He had counsel. He pled guilty in January 2012 in the Western District of Virginia and received, I believe, another 12-month sentence. And then he was released on supervision in, I believe it was November of 2013, 2 or 3 months after the Miller decision came out.
So you don't know if you're telling me 2 or 3 months. We know when Miller came down, and the question is, was it before or after Miller? You say it was after, but you don't know.
It was after. It was November 2013. We know that from the pre-sentence report that we've seen, and I'm happy to file a motion to put that under seal to have that in the record. But we know that when he was released based on the information in his pre-sentence report.
So
Your Honor,
it's not in the record, or it is in the record of this case?
Of this case,
Well, you're relying on it, so you can't rely on it unless it's in the record, can you?
we rely on.
I'm just asking you if you know. Pardon?
We asked the court to take judicial notice of the filings in the Western District of Virginia, which have the sentence and his supervision.
Have you submitted anything to us in that regard, about that date? And why would it have anything to do with this coram nobis thing? I mean, you've said something about it, but we don't have anything definite in the record.
Well, just that he was on supervision when Miller was deemed retroactive. But the defendant has never actually said that he did not know about Simmons or that he did not know about Miller. He has said nothing.
His lawyer, he's speaking through his lawyer.
But his lawyer did not make that argument to the district court. There was nothing in the defendant's pleadings as to why he waited. There was nothing about whether he had these discussions with counsel. We don't know because there is no reasons, and so that is why.
Have you asked his lawyer when he knew? You could talk to his lawyer and y'all find out, and you know what the facts are, and then the government could exercise its discretion to agree this fella is not. He doesn't have a valid conviction from 2003. He doesn't have one.
Well, and the government can consent to coram nobis. It is still ultimately.
Well, and the government does. The government does in lots of It's what they call the interests of justice. It's written across the top of the Department of Justice in Marble up there, wherever it is in D.C. Right? Equal justice under law. So the government wins, we used to argue, when justice is done. So it always wins, as long as justice is done.
Yes. This particular defendant has a lengthy criminal history, and this really gets to the adverse consequences. It's the government's position that this conviction had no effect on his most recent sentence. It is also eventually not going to be scored because of the length of time.
Well, she says it was scored in that last sentence when he, with his lawyer, agreed to waive the appeal.
It was.
And we didn't hear it because the government came in and pled the appeal waiver after it was on constructive notice that his 2003 conviction was invalid, and the government got him to agree to appeal waiver and get extra time.
I can't speak to if the government knew about that it was an invalid.
Well, you knew by constructive notice, just like you're charging him with the Miller case and the Simmons case. You're saying he should have known. Well, if he should have known, you should have known.
With respect to the guideline range, it was the government's position that he is a career offender and he is a level 6 regardless of this conviction. And then also the court could.
What about that $200 or $100 assessment they charged him? And the government still got in.
The defendant.
Isn't that a collateral consequence? And she says he paid it. His lawyer here says he paid it.
Yes.
For a conviction that's not a conviction.
Potentially. The defendant did not raise that as a collateral consequence.
Well, I'm raising it. I'm raising it right now. Isn't that a collateral consequence? He's paid $100 for an offense he didn't commit. It's not an offense. So you, the United States of America, owe him $100 plus interest from 2003. Would that be fair?
Yes, I believe the Supreme Court has said that.
So you'd say that's fair. So that's a collateral consequence. And Judge Widener says in the Mandel case that there were consequences because and Mandel was more than one petitioner, that they were branded as criminals.
Yes,
These
sir.
were lawyers and former governor of Maryland. They've been branded as criminals, and the Supreme Court changed the law on the mail fraud statute. And so they gave them a writ of coram nobis in 1988 here in this court. Why wouldn't that same principle, branded as criminals, apply in this situation? Is that distinguishable because of what?
Because of his criminal history.
Criminal history.
Yes.
Well, actually, and in Judge Hall's dissent in the Mandel case, he said these guys, they are out on a technicality because they changed that mail fraud statute. What they did is still criminal, is what he argued in the Mandel case. What they did was still violations of federal law, but they were not under the mail fraud statute, other statutes, and which would be different from this case because this offense is not an offense. It's not an offense any way you turn it under federal law, the one he was convicted of in 2003.
But he has other state felony convictions.
He does, but I'm talking about the facts of the case.
Yes, Your Honor.
The facts of the case in Mandel, the facts made him still criminals, according to Judge Hall in the dissent. And he opposed giving him a writ. In your case, 2003 is what we're arguing about, a 2003 conviction. That's all we got here is a 2003 conviction. That's not an offense, and you admit it. The United States of America admits that. You argue, but he waited too long, and he wasn't prejudiced. And as representative of the government, you're entitled to argue that. But you can't tell us that he's just simply a no account, I don't think, and get away with it.
Your Honor, I did want to add, with respect to this third prerequisite, the adverse consequences, every defendant who brings a writ of coram nobis to seek to have their conviction vacated necessarily has a conviction on their record. And so the adverse
But
consequences.
they got a conviction that's defective on their record. If it's coram nobis, which is really coram nobis, which is very rare. This is rare. Most lawyers, I don't know how many of you have had, this might be the first, and I expect this might be the first for the public defender. And it's first for a lot of lawyers and judges. Doesn't happen.
Do we know as to his criminal history, did he have any other felonies? Were they all misdemeanors?
Prior to his 2003,
Yeah.
he had 2 prior state felonies. It was larceny of the person and possession of cocaine. And then with respect to the 2003 conviction, he admitted that he was on his way to rob someone and that he had been involved in 3 other robberies, which is information that the district court in his most recent criminal case considered at the sentence. And then he's had 2 other felony convictions since the 2003 conviction, assault by strangulation, and I believe another possession of cocaine in state court. And then he had his federal convictions for the misdemeanor crimes while he was in prison. And then now his 2 most recent convictions for possession and carrying a firearm.
Well, hypothetically, if for example, he didn't have any convictions except for misdemeanors, and then he caught this felony conviction, wouldn't that be adverse to him based on how we view felonies?
Potentially, a felony, if that was his first felony conviction, that could carry certain civil rights violations or certain, not violations, but certain changes to his civil rights and liberties. And but that's not the case here. This defendant did have 2 prior state felonies before he pled guilty to the 2003 felon in possession. I see that my time is almost up, so if I may just briefly conclude.
Go right ahead.
The government would ask that this court affirm the district court's decision because the district court did not abuse its discretion. Thank you, Your Honors.
Thank you. Ms. Tarleton?
Thank you, Your Honor. I'd be happy to answer the court's questions. I just wanted to respond very briefly to my friend on the other side's suggestion of waiver. The government never mentioned the word waiver in its brief, and this court has held time and again that the government can, in fact, waive any waiver argument. That's in United States against Cawthorn, 726 F. 3rd, 503, 509, Note 5 from 2013. And with respect to adverse consequences, I would note that the government has cited no case in its brief that would suggest that this court has ever denied coram nobis for failure to show adverse consequences, certainly not in the circumstances we have here of actual factual innocence. I'd be happy to rest on my argument and briefing unless the court has any further questions.
That's fine. Thank you very much for your help. We appreciate it. And we'll take the matter under advisement, and Madam Clerk, we call the next case.
For our second case today, we have case number 20-4095, United States of America versus David Harris Miller.
Very good. And Ms. Levinson? Mr. Levinson, I'm sorry. Good to have you here, sir.
Thank you very much. Good to be here. Okay, please the court. Good morning, Your Honors. I'm Andrew Levittown. I represent David Miller. I don't understand what happened in this case and why it happened. You really have to understand David Miller's wife's case a little bit. His wife was named Lynn Wallace. She pled guilty to conspiring with David Miller to defraud his former employer, which is called Skylink. She also admitted in other crimes evidence that she had embezzled money from the State Center of Saslaw and from the CCAID, which was some sort of not-for-profit type entity.
What would be where are these facts going? Which issue are you pointing these facts as helpful to understanding?
Sure. Misjoinder issue and the Fifth Amendment issue. So you have to understand sort of where this came from in order to understand that. Because in the aftermath of her case, what happened was,
When you say the Fifth Amendment issue, you're getting at the question of her testimony at the trial not being allowed.
correct, Your Honor, the government said,
You wanted to call her as a witness, as a defense witness.
that's correct.
Okay.
What
And the
happened-
judge,
the government stated that her testimony would not be material, even if the jury believed he was not guilty of the Saslaw offense and the CCCAID offense, because the government had put all three offenses together in one count as a conspiracy.
and you stand, the government objected to her testimony,
Yeah, the government,
and her lawyer objected to her testimony.
now, the government asked the court for blanket immunity. In other words, she sought blanket immunity. The government went to the court and said,
The government asked for blanket immunity?
no.
What are you talking about? What about blanket immunity? Where does it come from?
When Lynn Wallace was compelled to testify by David Miller, she sought,
You wanted to call her as a witness, correct?
correct, Your Honor.
Did you subpoena her?
Yes, she was actually in the court.
Was she subpoenaed?
I think what happened there, I was not the trial lawyer, but my recollection of what happened there was the court brought her to the courthouse, and that the defense counsel had not subpoenaed her properly.
Was she in custody?
Yes.
She was in custody. Well, you couldn't have subpoenaed her. You needed to get a writ, habeas corpus sod test of a condom.
What difference was it going to make if she invoked her spousal testimony privilege? We're not just talking Fifth Amendment.
Yeah,
So how are you going to get around that? She didn't have to testify.
well, there's a couple things. Number one was there's an exception to spousal immunity on a testimonial privilege if she's a joint participation in the crimes, even if she's not charged. That's Fourth Amendment law. The other thing is the court.
If she is in joint participation with the crime, what?
If she's a joint participant in the crime, then there's an exception to spousal immunity.
Is that like the crime fraud exception for attorney-client privilege or something, too?
Similar.
Similar to that? There's a loophole for their spousal immunity if the
Well, the court's.
if the spouses are involved in a conspiracy like this?
Yes, Your Honor.
So that's what, did you brief that point here?
I didn't brief that point, point, Your Honor, and the reason I didn't was because the court in,
How many, your clients had several lawyers during the course of this thing,
correct,
correct? Did you write the briefs? You said, you just told us you didn't try the case.
no, I did write the briefs,
You wrote the briefs, but you didn't try the case.
right.
Okay. So, but she was in custody. She was available to testify. The government objected. Her lawyer objected. You wanted her to testify.
Correct,
And the judge sustained the objections.
right.
And that's your primary issue on appeal. Is that right?
One of the issues, Your Honor.
Well, you don't say a primary. How about a primary issue on appeal? Is that you were not permitted to call a witness
Right. And this would,
who would have helped your client. Although what you agreed, the stipulation at her guilty plea implicated your client.
that's incorrect. And the government states that over and over again, stated it in court. If you look at the amended information, you look at the plea, you look at the statement of facts supporting her plea, the government's absolutely wrong about that as a matter of, as a factual matter. When the government states that she implicated David Miller in the SASFA offense, the CCCAID offense, and they didn't even mention, but I suppose it would have to be also the money laundering conspiracy. That's not accurate. In fact, they amended her information specifically because of that to state that she only implicated David Miller on the conspiracy on the Skylink fraud.
So you responded to me, there was an exception, and I'm just trying to, and I'll check it to be sure. You know this better than me, you've studied this to that degree, but isn't there such a thing called a marital privilege? And there's a difference between a marital privilege and what was asserted here was a spousal testimonial privilege.
There's two types of privilege, both called marital or spousal.
We're not talking marital privilege here, we're talking spousal testimonial privilege.
It's spousal testimonial privilege, but, and you have to be a spouse. There's a case on that out of the Fourth Circuit where the woman wasn't really a spouse, and they said you have to be a spouse, so you could probably call it marital privilege as well. I think I have that case. It's U.S. v. Parker, Fourth Circuit, 1987. I don't have the site with me. I wish I did. I probably have it in some other papers, but that's the case. It says the testimonial privilege is an exception to the testimonial privilege for joint participations in crime, whether they're co-defendants or not. So I'll also say this, Your Honor. On the court docket itself, the trial court said that it decided this issue on the Fifth Amendment grounds. It said that in court, but later, after David Miller filed some motions for new trial, after he filed his motion for reconsideration, which is document 84, after that, the court said, oh, let me talk about spousal privilege. So the court did cover it, but that wasn't really the basis of the decision.
What did you say the basis was, the Fifth Amendment?
The Fifth Amendment.
So what was your proffer as to how her testimony was going to help your client? What did you proffer that as to what she's going to testify? She's going to testify. You say she's in the crime with him. So, I mean, presumably she's not going to help him at all if she's in with him. But you have a proffer because you say, did you make a proffer to the court as to what she's going to testify to?
That's why I wanted to start with the Lynn Wallace case to explain that a little bit. But I'll tell you what happened here. She had pled guilty 4 years before this case.
Was that your proffer that you're going to, as to what her case, when you said it to the district court, you says, I'll tell you what she did and how she, or did you say, she will say this?
Your Honor, there is no proffer in this case. I don't think it's required by the rules of procedure. This court.
You don't have to tell the court how her testimony would help you.
Not if the court already knows it. The court have been dealing with this.
You can assume that, you say,
Well, you can see from the testimony,
that she's going to help him on that stand.
Was her guilty plea before the same judge?
Yes. And the entire thing was discussed by the court. So the court knew exactly what she was going to testify to. There's a long discussion with her defense counsel. There's a long discussion in court with the government's counsel. Everybody knew what she was going to testify to. She was going to testify that her husband was involved in Skylink. He was not involved in anything else. He didn't know about it. and she's going to tell the court why.
But she pled guilty to the conspiracy with Miller to defraud all three of them. Skylink, the Caution, the Consultant, and others. She pled guilty to that.
No, she didn't. She pled guilty to Skylink. Other crimes evidence, she said in her other crimes evidence that she admitted, she stated she committed these crimes. She did not say that David Miller did.
So she didn't plead guilty to the conspiracy.
She pled guilty to the conspiracy.
Only as to just one.
Right, Skylink, only Skylink. The other two, they amended the indictments, or the information, so that they clarified that point.
Well, that's what I was speaking to, the amended information. And you said she didn't plead guilty to that. The amended information did include all three, didn't it?
No, the amended information.
Just the one that you say it did.
And it listed other crimes evidence. And it separated into two parts. Here's the conspiracy part. Here's the other crimes evidence piece, non-conspiracy. It's very clear. The government says it's not, but, you know, this is a de novo review on this issue, and you guys should take a look at it. I think we've laid it out pretty well in the briefs.
Are you both, were both of them lawyers? Your client's a lawyer.
He's a lawyer, his wife is not, she's an accountant.
His wife's not a lawyer.
Right.
Well, but according to the briefs, they formed a law firm. That's not right? They formed law practices. How did they form law practices if she wasn't a lawyer?
You have to ask the government.
Well, I thought you filed a brief too. I thought, the way I read it, you both were saying that had these law firms.
I don't think, no.
But you're saying she's not a member, she's not a lawyer. He is,
Right. Now, to get back to the.
or he was. I don't know if he still
Right,
is.
it's just part. Now, to get back to this misjoinder issue for a second, this misjoinder also affected.
Misjoinder? Misjoinder.
Count one, Your Honor.
You're talking about misjoinder of counts? What?
Count one,
You're saying it's duplicitous?
correct. In count
But
one,
that's, that's different than a misjoinder.
the government did, Your Honor, was it took three counts
Misjoin-
that were not related and put it into one count. Okay?
So they put three counts into one count? That's what you're saying?
Charges.
Did you preserve that claim?
Different crimes. Your Honor.
Did you preserve that?
Yes.
Did you raise that issue with the district court?
It was raised not only in a bill of particulars that were filed on that very issue in a motion to strike by Bill Cowden and Steve Webster. I think it's documented.
Did you move to dismiss that count on account of duplicity?
They moved to strike it, Your Honor. And then in David Miller's motion for reconsideration.
Did you move to dismiss it? No.
In his motion for reconsideration, he raised it as well.
As to this particularized inquiry, is it your view that that inquiry should have been done question by question, or can it be if she asserts the Fifth Amendment privilege?
That is one of the largest issues. The scope of the privilege was unnecessarily broad. It was based on facts that were not accurate. Now, it was clearly asked her about SAS law, CCCAID, and money laundering. It clearly asked her about all kinds of things. But the court ruled for a blanket Fifth Amendment privilege. That's certainly one of the larger issues.
Now, we review that question de novo or abuse of discretion?
Well, it's a de novo review. It's a constitutional issue.
I thought evidence admissibility was abuse of discretion.
I'm sorry, Your Honor.
Admissibility of evidence, we review for abuse of discretion.
I think you could, unless it touches on a constitutional substantive right, like a Fifth Amendment right. And not only that, but
What constitutional provision are you talking about?
Fifth Amendment.
Fifth Amendment.
His Sixth Amendment right, her Fifth Amendment right.
Did you raise the Sixth
Yes, Rick.
Amendment right below about not by allowing a Sixth Amendment challenge for not letting Wallace testify?
Your Honor, there was the, oh, I'm sorry. I think it was in his amended new trial motion that the court said was late, but the court then issued an opinion relating to it.
I didn't see in the record that the Sixth Amendment right was raised.
Well,
Are you sure?
It's in these new trial motions, Your Honor. And I didn't see them until I was preparing for this either, quite frankly. But there was 3 of them filed by David Miller, who's not really by his attorney. First one was a motion for new trial. My recollection is it was one.
That's after the fact.
That's correct, Your Honor. After the fact, it's certainly still before the trial court. And that's sort of the issue. And then it was raised.
So you say making a motion for a new trial preserves an issue of an evidentiary fact that occurred during the trial that you did not object to?
Let me give it.
When you come back, I'd like to hear the case you have that supports that.
Let me think about that testimony at trial and what Drew Hutchinson did during the case, because he was wishy-washy, to say the least.
Who's Drew Hutchinson?
Drew Hutchinson was the CJA lawyer that was appointed.
Yeah, oh, that was his lawyer. Yeah, well, I'm not so sure that, and I'm not trying to help you here, but that's like, am I making an observation? That if you try to, if you want to call a witness and the judge keeps it out, why doesn't that preserve your point?
I think you're right, Your Honor.
Well, but that's the way I always tried to do.
I appreciate the help.
I don't know whether you have to raise it afterward or not, but they're saying you don't have to, you didn't raise it properly, you didn't preserve it, but I don't know whether it makes any difference or not.
Certainly before the
But I'm not, it may be abuse of discretion review anyway.
Right.
But anyway, let's see what the government has to say.
my time.
You save some time. Ms. Bateman?
Thank you. Good morning, Your Honors, and may it please the Court. Samantha Bateman for the United States. This Court should affirm all of Defendant Miller's convictions because, as the Court recognized when denying his repeated motions for bond, none of his challenges to those convictions succeeds. The vast majority of Mr. Miller's arguments on appeal, including the Sixth Amendment compulsory process claim, were forfeited by not being...
How was the Sixth Amendment claim forfeited? He wanted to call the witness.
He didn't make any argument based on the Sixth Amendment.
He wanted to call his witness. He says, I want to call my wife as a witness, and the judge and the government objected. Her lawyer objected, and the court sustained the objection.
To be clear, the government...
What else can he do? He wants to call his witness, and the objection sustained. He has offered to call a witness. I think he has preserved that.
I understand he wanted to call...
You may have an argument about whether the judge was right or not, but I don't think I don't know how you say waived her testimony. He tried to call her.
So to be clear, if he wanted to call her and make an argument that he was denied his compulsory process rights, he would have had to make, as Judge Wynn asked, some
Well,
kind
you
of...
everybody, all the lawyers in the courtroom had taken constitutional law, and they knew the Sixth Amendment gives a criminal defendant the right to call witnesses. And the judge says, whoever the lawyer was, Mr. So-and-so, call your witnesses. Yes, sir, I call my wife. Objection sustained. That's preserved.
I understand he wanted to call the witness. He didn't make any proffer, though, which he was required to do.
Well, is there something in the Constitution about a proffer? No.
This court's
It says you can call witnesses. You're entitled to defend yourself.
Well, this court's cases say that in order to find a violation of the Sixth Amendment, and the Supreme Court said this in Valenzuela-Bernal as well, the defendant bears the burden of showing that the testimony is material and vital to his defense. So it was incumbent on him to say something about what she would have said on the stand. We can't engage in speculation at this point as to what she would have testified to, particularly...
Well, the judge had taken, and the government had prosecuted her, and the government had taken her plea. You all knew everything about whatever it was that she knew. I assumed you'd interviewed her and all that kind of stuff too, that she was a cooperating person probably with the government.
We didn't call her as a cooperator. What we knew is she had been interviewed.
You didn't call her, you objected to her testimony.
To be clear, we
And
did
he said,
not.
I think she'll help me. I think she'll help me. He wanted to call her.
Actually, his counsel said at Joint Appendix 1352 to 53 that he agreed she wouldn't help him. And the government didn't object to her testimony. She invoked through her counsel.
So that's
her
the point I
spousal
want to be
testimony.
clear on. Did the government actually object to her testimony? Because it looks to me like it was her attorneys who told the court she would not testify.
That's absolutely right. Then the court.
So the
asked-
government didn't object.
No, we had no position.
Okay, I thought you had just admitted it. He said the government objected, but just a few minutes ago, didn't you? I thought when I asked you that you agreed with that, but now you're saying you don't. Okay.
It's not correct that we objected. We explained to the court that she was invoking, as her counsel had told the court, her spousal testimonial privilege.
Well, did you want him to testify or not?
It made really no difference.
So you didn't take a position.
We were prepared to cross-examine her if she testified.
Did you-
on his behalf. We just answered the court's questions so that the court could understand why she was.
Did the court ever ask you what your position was on whether she should testify or not?
I don't believe so, because that really wasn't the government's call to make.
Okay. The only objection was presented by her own lawyer,
Correct.
who on the face of it had a valid issue to raise, or two issues to raise.
Right, and either one of those would be independently sufficient.
You didn't object to his interposing objections.
No, and I don't believe the defendant.
Were you the trial lawyer?
I was, Your Honor.
Okay, so you were there. So we got somebody was there. That's good. Yeah.
Yes, and it was her lawyers from the Federal Public Defender's Office who represented her during her plea, and they came in before. We never had a chance to speak with her. We never interviewed her at the prison while she was there. They came in and said she wanted to invoke not just her Fifth Amendment privilege, but also the spousal testimonial privilege. And I know
What
there were a
about
number
the
of
exception
questions.
to that? Is there an exception to that?
No, my understanding is the exception is for.
What do you mean, no? The opposing counsel said there's an exception to spousal testimonial privileges, just like marital privileges.
There might be an exception.
So somebody has to be wrong on that. There's either an exception or not. You tell me there's no exception to it?
For the spousal testimonial privilege, that's one that's vested in the testifying spouse, and it wouldn't make sense for there to be an exception to that. Certainly for the marital communications privilege, those are the communications, and if they were during the marriage but in furtherance of a crime or fraud, there certainly is an exception that evidence can be presented.
Maybe he can give us the
Fraud.
case law when he comes back, the site where he finds there's an exception to a spousal testimonial privilege here. Tell me, what did she plead guilty to? Now, I understand that the court should have known she'd been helpful, even if there's no proffer. The best thing is the court should have known, be helpful to say that he had nothing to do with the consortium and Saslaw frauds. Did she plead guilty to any conspiracy that would involve those entities?
Yes, so her, the
What do you mean, yes? He said no. Did you not hear the counsel on the other side? She said no. He did not do that. It was only one way. So tell me why you say yes.
The amended information to which she pled guilty is that supplemental appendix 3413 to 14. And it alleged all of the conduct in violation of the conspiracy count 1349. All of the conduct included not just Skylink, but also the frauds on the consortium's donors and Senator Saslaw. Now, she was silent as to what exactly her husband knew when and whether he participated, what exactly his role was, because frankly, we did interview her, and her testimony on that was inconsistent.
I thought you said you didn't interview her.
We didn't interview her while she was at the jail in the courthouse being held awaiting testimony. She made progress.
You interviewed her after she pled guilty.
Both before and after, and she said.
Before and after. So you all had talked to her ad nauseum, I suppose, about all this.
Right, and one of the reasons we didn't call her was because she told different stories every time she was interviewed. So for example.
Well, the juries can figure that out. You can't say you witness not allowed to get on the witness stand because they've told different stories. I mean, the government calls people all the time that told different stories. The juries figure out what the truth is and what it's not. And if they tell conflicting stories, the lawyers impeach them with the stories. So
That's
what
true.
I don't know. That doesn't help you arguing that she's going to tell different stories.
Her concern was that she might be prosecuted for having told those different stories.
Well, she may have had a valid concern with that, and her lawyer could raise that.
And that is why
whether
I
you be
think we
prosecuted or
should.
not, but if actually you tell different stories is not, I don't think that's a ground to let somebody, keep somebody off the witness stand.
It is when the
In a
witness-
criminal trial, where there is a Sixth Amendment right, and everybody in the courtroom knows there's a Sixth Amendment right for a defendant to defend himself. And a lawyer has to defend himself. A competent lawyer, effective assistance of counsel, can call witnesses. It's in the Sixth Amendment, right?
That's correct. It would have to be counterbalanced against both her Fifth Amendment privilege against.
No, but the primary interest at the trial is the interest of the defendant in the defense,
Well,
right?
this court's cases under the Sixth Amendment say that you can't compel a witness to testify if they have a valid invocation of privilege, and there were two of them here. Now, the district court did also rule, Judge Wynn asked some questions about the spousal testimonial privilege. The cites for that are Joint Appendix 1463, 1655 to 57, and 1722 to 23. So the court, both orally and in writing, made a ruling on the spousal testimonial privilege, and that alone was enough to keep her off the stand here.
We reviewed that for abuse, that ruling for de novo or abuse of discretion,
We'd submit it's actually plain error because he didn't raise the Sixth Amendment compulsory process.
because he didn't say Sixth Amendment. Assume that he did preserve it by trying to call her. Is it reviewed de novo or for abuse of discretion?
We would submit abuse of discretion. I don't think this court has actually decided what the standard is for a preserved claim. Our argument is that it was not.
We've got cases going both ways, maybe.
I don't
maybe
believe the court has passed on that question. I think Your Honor hit the nail on the head earlier, though, by saying that it's really an evidentiary question, and so it would
Well,
probably.
it is an evidentiary question, but it's a constitutional question too. And you know that, and I know that, and everybody in the courtroom do it.
Right, and here I think the district court was faced with, there were countervailing constitutional interests.
Are you ever heard of the old Rhines case?
Yes, Your Honor.
I mean, that went in bank over an issue of whether a defense lawyer could call a witness.
My understanding of that.
You remember that?
My recollection of that case, Your Honor would certainly know better, but that it was a slightly different situation where they kept the defense witness off the stand because there had been some kind of misconduct or the defense witness wasn't supposed to talk about certain things with counsel and that had been violated. So it's sort of a different situation. It didn't involve there an invocation of any privilege. And that's what we had here, an invocation of the spousal testimonial privilege, because the thrust of her testimony.
But they kept the witness off the witness stand in the Rhines case,
That's correct.
and the conviction was reversed. And he got a new trial as a result of the witness being excluded from the in-bank court in the year 2000 or 1999. Is that right or not?
I believe that's correct. I would just point out that it didn't involve any invocations of privilege. So the witness here wasn't kept off the stand willy-nilly.
It involved the Sixth Amendment.
Yes, it involved.
It involved the Sixth Amendment, the right of a defendant to put on a defense and call a witness.
And to get back to-
we said he was deprived of that.
Right, to get back to it, if for him to make out a claim that he was deprived of that, he has to show that the testimony was material and vital to his defense.
Did the district court conduct a particularized inquiry about the scope of Wallace's Fifth Amendment privilege?
Yes, there was an extensive colloquy with Mrs. Wallace Miller's counsel. But again, because the defendant didn't make any proffer as to what her testimony would have been, nobody had a target to shoot at. And so I do think this court could also look at, there's a DC Circuit case, US v. Thornton, 733 F. 2nd 121, where the court sustained keeping the witness off the stand based on a blanket invocation of privilege, where the defendant had made no proffer, and so the court said there was no need to make any more searching inquiry. And that's what we had here, is the district court had no idea what her testimony was going to be. It had changed throughout the time that she had been interviewed and making proffers with the government, and the defendant never said anything about what she would have actually testified to.
So, well, is that inquiry required?
The court is supposed to make some kind of inquiry, yes, into whether there are subjects that the witness can and cannot testify about.
Well,
That's what happened here.
How do you get I've litigated some of this on both sides over the years. And it's always been a question of what kind of a proffer or questions you can ask when there's a Fifth Amendment assertion made, and the client is getting legal advice, don't testify. It can be a violation of the Fifth Amendment to tell the court what the client would say. Be a violation of the attorney-client privilege for the lawyer to tell the court or proffer to the court what the client might say. It's a tight situation in those things.
I agree.
And a lawyer tells the client, advises the client, supposedly knowing what the client's going to testify to, she's got to take the Fifth Amendment. Can't testify. How far can a trial court or even the lawyer go in telling the trial court what kind of information supports that? I've advised her to take the Fifth Amendment. She can't testify. She's going to get herself in trouble.
Right, and that's what happened here. The district.
And that's
court-
almost the end of the deal, I think.
That's right, and that's all really the district.
No, that's what, I think it's a situation that's tough for everybody concerned.
I think it is a delicate dance and a delicate balance here, and the district court ably navigated that by asking questions of her counsel.
You had a great judge, an experienced judge. You've been through a lot of these things.
At some point in time in the interrogation by the United States, she either denied involvement herself in certain of the aspects of the case, or she admitted them. And so, in any event, if she were to get on the stand, she's got herself in jeopardy.
I think that's right. She'd be in quite a quandary because if she testified, for example, that her husband had no idea about defrauding the consortium donors, the community colleges, she had made statements before that she talked to her husband about it and they jointly agreed it was okay to take money out of that account because it belonged to them.
And what she has said, either admission or non-admission, is across the board as to all the entities that were defrauded.
Eventually, she pled guilty to defrauding all of those entities, but her statements to the FBI, both before and after her plea, often contradicted what the defendant claimed.
But she pled guilty to an information that had all three of them and in the conjunctive.
That's correct, and the very last line of the information was all in violation of 18 U.S.C. 1349, which she can't conspire with herself, so by definition, she was conspiring.
And 1349 is the conspiracy statute.
That's correct, Your Honor. So we'd submit that this court can affirm based on either her invocation of the Fifth Amendment privilege, because she would have put herself into that quandary of having to either contradict her plea agreement or contradict one of her sworn statements to the FBI. There was also that issue about him wanting to accuse her of a new crime, forging his signature on some mortgage documents, and that wasn't contained in her plea.
I don't like to be repetitive, but I want to make sure I understand. That is to all the crimes in terms of her statement. She pled guilty to all of them.
She pled guilty to
And she
all of them.
made statements prior to her plea that differ from what her plea was.
That's correct.
And so if she got on the stand and said her husband didn't know anything about this, that would be a lie.
She could be prosecuted for the false statements before or for perjury. Yes, one of those statements would have had to have been a lie. Because
And that's because of the way the government charged this case, which I hate. Instead of charging the substantive offenses, you charge conspiracy. So that's what put her in the jam.
I think it's really based on the defendant and his wife's conduct that it was all interrelated. It was all part of the same.
It was one crime. It wasn't multiple crimes she pled to in that conspiracy count.
Right.
It was a conspiracy offense, singular,
Correct. And I know
but with multiple objects
yes, the mail and wire fraud were the separate objects.
and different victims.
And the different victims were sort of the manner and means.
But it was one offense,
That's correct.
and she was into it with him,
correct.
with her husband.
Correct. And that's what he was.
That's the
charged
crux of the whole thing.
That's right. And that's what he was charged with as well. I know now he's raising what is a duplicity argument. I want to be very clear, that wasn't raised below in the Bill of Particulars or anywhere else. And if you look at Joint Appendix 95, he disclaimed making any duplicity claim. His trial counsel said, quote, "This is really just a..."
You're saying duplicity was not preserved.
It was waived. He said, quote, "This is really just..."
You're saying it's not preserved.
Actually, we're saying something even more than that, which is that...
I know you are trying to. I'm trying to.
At a minimum, it was not preserved, but actually he said, quote, "This is really just a charging decision within the power of the government." And at District Court Docket 72, the court said he wasn't contesting the decision to charge count 1 in a single conspiracy. So it's not just that he didn't think about it and didn't preserve the argument, he actually affirmatively disclaimed that argument. So we don't think this court should even reach it at this point. But to the extent the court is interested in that argument about the duplicity of count 1, there's a wealth of authorities in this court, the Tohachiao case comes to mind and others, where anytime there are an overlap of the main actors' methods and goals, that's a single conspiracy, and that's what we had here. There were 2 co-defendants. They were operating over the same time period, defrauding multiple victims.
Was this duplicity as opposed to or multiplicity?
He's arguing duplicity. I'm sure if he had been charged in 3 separate conspiracy counts, he'd be up here arguing multiplicity, and that's why this court...
One of them's bad and one of them's not. Duplicity is the one that he needs to be arguing, I think.
That's the one that he's arguing.
Yeah, no, but that's one he needs to be arguing. Multiplicity would be much question about the validity of that.
Right, but this court has said in Robinson that multiplicity and duplicity are sort of a Scylla and Charybdis.
And duplicity can violate the due process clause.
That's correct.
That's what the defect is. Violates Fifth Amendment.
Right, and he's
Try to
arguing
cause-
duplicity now.
Charge multiple offenses, you get it all messed up.
And I also would like to emphasize in my remaining time that even if this court found that he was only responsible for the Skylink portion of the fraud, that was enough to sustain the conviction under count 1. That is enough to establish the mail and wire fraud conspiracy, and then also the fraud proceeds were laundered and spent often in increments exceeding $10,000. So that was enough to affirm count 2, the money laundering conspiracy. Counts 3 through 10 are all substantive executions of the Skylink scheme, which Mr. Miller tried to deny to some extent at trial, but now effectively admits having committed those crimes on appeal. So on any of those bases, this court could affirm his convictions on count 1 through 10 simply on the basis of the Skylink conduct that he has now admitted he engaged in. Thank you, Your Honors.
Thank you, Ms. Bateman. Mr. Leviton?
Thank you, Your Honor. The government says it didn't object to Ms. Wallace testifying. But what the government told her that if she testified, it was a government's position that she would be subjecting herself to perjury. And it based this on this misstatement as to the plea. Misstatement as to the plea is she pled to 1 conspiracy.
You're saying the government did object to her testimony and said if she testifies, she's going to be prosecuted for perjury.
Correct. And they also came up with a tangential issue having to do with some bank fraud and said, even if the defense counsel didn't bring it up, they'd bring it up on cross-examination. So the government very clearly did not want her to testify. Now, the colloquy with the court and counsel, her defense counsel, said JA 1463 to 64, clearly talks about these issues as to what she would testify to.
Why didn't the government want her to testify? What was she going to say?
She was going to say 3 things. He wasn't involved in SAS law, didn't know anything about it. Same thing with the CCCAID, and that she hid all this money laundering activity from him. And that she not only hid it, she also she lied to him about it. So that's what she was going to say.
So your client did admit to a conspiracy insofar as Skylink.
He did.
Using the fake entities that he created.
Correct.
And were these the same fake entities that were used to funnel funds stolen from consortium and SAS law?
There was no fake entities used to funnel funds in SAS law and CCCA.
So you're saying that those fake entities were not the fake entities that were the subject for his pleading guilty to, or at least admitting to conspiring to defraud Skylink, were not the fake entities that were involved with Skylink, with consortium and SAS law.
Let me clarify what I'm trying to say, Your Honor. In the SAS law and CCCAID, situations, those entities' bank accounts were involved in that she sent checks or wires to those bank accounts.
Didn't he help her get those positions with
No.
those entities? He didn't help her?
Senator Saslaw testified on the stand. He said that his former treasurer had gotten ill, and she had recommended Lynn Wallace. Now, Senator Saslaw did know David Miller. But the government has said over and over again that he got her that position. I also want to point out a couple other things that I think are really egregious in terms of what the government has been saying, and the court's been saying over and over again. It starts with these Jamaica flights. They keep saying that Lynn Wallace was engaged in conspicuous spending after David Miller was fired in May of 2014. Well, in preparing for this oral argument, I looked at those flights. Every one of them were booked well before 2014. One in 2011, one in 2012, one in 2013. And then they talked about his country club dues, like he was a big country club spending all this money. But there's 60 pages in the exhibits that show that this guy was way behind. They kept wanting to throw him out because he wasn't paying his bills. Then they talked about the fact that she's spending money, so he has to know that she's money laundering. Well, the government admits at sentencing, the government admitted in the Wallace case, that the guy made $900,000 in consulting fees during the same time period. And then when we talk about the money laundering count, we also have misstatements of the law constantly. You know, money laundering by Lynn Wallace equals conspiracy. SUA funds, the same as fraud funds, are not distinguished. The legal theories, the presentation of the evidence, 3 days of testimony on Lynn Wallace's 12,500 transactions, none of which involved David Miller. The presentation of this case was the government was trying to do a do-over on the Lynn Wallace case because it was unable to forfeit his houses. That's what what motivated the government in this case. That's what this case was really about. I have 25 seconds left. I want to make one point, Your Honor. The misjoinder, if you believe that there was not a proper modus operandi, but these three things were not all the same. And we've gone through this in detail in the brief. If you agree with that, it also implicates the right to counsel, the Sixth Amendment right to counsel. And that's because the amount of loss for the Skylink was $368,000. They froze $1.4 million. He could have paid for his attorneys otherwise. Thank you, Your Honor.
Thank you very much, sir. If we were doing things the way we used to do it, we'd come down, greet counsel, and shake your hands and tell you did a good job. And you have, so I'll just take it from here that you did a good job, and we're good to have you here. And Madam Clerk, we're going to take a 5-minute break, and then we'll reconvene for the next two cases. Thank you very much.
This honorable court will take a brief recess.
Good to be with you all. Our next case is Sorto Goodsman versus Attorney General Garland. Mr. McKinney, good to have you with us, sir.
Good morning, Your Honor, and good morning to all of you in council. May it please the court. My name is Jeremy McKinney of the North Carolina Bar, and I'm arguing on behalf of petitioner Zoila Sorto Guzman and her minor child. Now, I'm arguing this case. This case was actually filed and briefed by my former associate, Jeffrey Whittison.
But you're the only one we have here, so you're on the hot seat.
Absolutely.
So,
And,
yeah,
as I was preparing for the argument today, I was struck by one phrase in Attorney Whittison's request for oral argument, which is usually not noteworthy, right? A request for oral argument, but I think it sums up this case in one sentence. And what he wrote was, while the dispositive issues raised in this appeal have been recently and authoritatively decided, the BIA is not recognizing it as such. That is truth.
They don't like the fact that death threats are looked unfavorably,
Right. I think
looked on unfavorably by us. Right?
I absolutely agree with that statement, Judge King. But if we think about just the briefing itself, cited almost 2 decades worth of cases from this court, published decisions that said a credible threat of death constitutes persecution.
Well, let's make sure that the record is clear. Did the IJ find that Sorto received a credible death threat based on her religion?
What he said was, this is at AR 51.
You can take that mask off if you like.
Oh, I'm sorry. Thank you, Judge King. At AR 51, the judge said, during this encounter, the Mara 18 gang members told the respondent that if they found her attending church again or wearing the cross again, they would kill her. That's the judge's finding.
Right.
He found the respondent to be credible, and he gave her testimony, quote, full evidentiary weight.
So that's the fact of the case.
That is the fact of the case.
As to the first threat.
As to the first threat. Now, if the BIA...
But they say, well, he didn't kill her.
that the actual
In their brief,
IJ literally said that.
I think it's in their brief, they're saying, well, he didn't follow up on it.
Right.
Well, it was conditional, as I read it, if she couldn't go back to church and she couldn't wear the cross.
Correct, Your Honor. And she didn't.
And she didn't. So she fulfilled the condition.
Right.
Based on the record here.
Right. And, this phrase is not quoted often in the Fourth Circuit, but is quoted widely elsewhere. And that is a version of persecution where the persecutor seeks to overcome a belief or characteristic of the asylum seeker. It's exactly what we have here. That's exactly what we have here. You have a threat of death used to overcome a belief, a value system, mind you, of the asylum seeker. The fact that the persecutors did not go through with it is fortuitous. We wouldn't be here right now because my client would be dead. But what we did see was continued violence between the exact same persecutors and the exact same asylum seeker.
How many threats were there?
There were at least 3.
3, but only one was directly tied to going to church or wearing the cross.
Correct.
That was the first one.
Correct.
And the other 2 were within 60 days. They're about every month.
Also correct. So what happened, you had the first incident in front of the church, directly tied.
And they say the second two are not relevant. They say, I'm talking about the Attorney General.
immigration judge in the
Attorney General says they're not relevant. The next two are not relevant because they didn't say anything about religion in the second two, but they were death threats.
Correct.
Did you I don't know how much of a criminal lawyer you are, but have you ever heard of Rule 404B of the evidence rules?
I'm going to have to admit my ignorance, Judge King.
It's what we call similar act evidence
Right.
in the criminal rule, but if you can prove a pattern of conduct or intent or that kind of thing. And they do it in drug cases a lot. They charge one count of a transaction down on the corner, and they'll have they'll prove 6 or 8 that occurred every day around it, and show the pattern.
What we also see, Judge.
So that's kind of this reminded me of 404B evidence, and we've said that 404B evidence is inclusive. It's part of the proof, like the res justi of the case in criminal cases. I'm not saying that it has anything to do with this, but this reminded me of the 404B rule, because we get a lot of these criminal cases where the government's all the time charging one count and proving 6 or 8 of incidents to prove the one.
Correct.
And that's the Attorney General's people that's doing it.
While I think that the incident in front of the church, what we would call the initial encounter, checks all the boxes in and of itself, by itself, what happened later informs that incident, and it actually provides a bit of steel to the threat. It provides credibility to the death threat.
Well, as a matter of fact, in 2018, in a Whitaker case, the court held the threat of death alone constitutes persecution, and an applicant is not required to prove long-term physical and mental harm to establish past persecution. So so the first incident would, in and of itself, be enough, from your view.
That is exactly my view, and it is a point that this court continues to make. During briefing, this court said it again in Bedoya versus Barr. After briefing in this case, between briefing and today's oral argument, this court said it 2 more times in Arita Darris versus Wilkinson and Portillo Flores versus Garland en banc. The point has been repeated over and over again, but
Do they want the government want us to change the law with this panel? Is that the way you read what they're arguing in this case?
the way that I read the department's brief was that they want the court to perhaps engage in some kind of more extensive test of what constitutes a credible death threat, whether it was written versus oral.
Well, they get that one. That's that Bedora case.
Correct.
I think I was involved in that, and I said something about the written threats.
And
easier to prove if it's a written threat, I guess.
it's easier to prove, but the board, at that point, the government was arguing that it wasn't as immediate because it was there was a detachment there. It was a text message. It wasn't a threat made orally or in person where you had that threat of imminent danger, imminent violence. And what the panel made clear was that that's not necessary. That is not necessary. That written forms can be as menacing as an oral threat. Now, the government here seeks to or suggests that maybe that should be a test on the strength, whether it was written versus oral, but that was not the point, we would contend, of the panel's decision. It was actually the opposite, just pointing out that a written threat could be as powerful as an oral threat.
But the general proposition, one panel of this court, under our rules of precedent can't change the rulings of earlier panels, or certainly not of the in-bank court. Only the Supreme Court or the in-bank court can change earlier panel rulings. I mean, if when party doesn't like what we have said in the earlier cases, which might be controlling precedent, they have to get the in-bank court to change it. Now, they could be setting that issue up for in-bank review, or try to get it up there, but
Yes, but I would still view it as not going back to the Rule 4B, I believe you said, Judge King.
I said 404B.
404B, I apologize.
I think it's in the, and I may have said the criminal rules, it's the rules of evidence.
Rules of evidence.
404B, rules of evidence.
Right. Which, of course, famously don't apply.
Similar acts.
Thus my unfamiliarity. But it was really the immigration judges, and again, this decision was fully affirmed and adopted by the BIA. They only underscored where they agreed with the immigration judge, but they did not add any additional reasoning. The decoupling of the first encounter between the asylum seeker and the persecutor from the rest of their encounters is an equally egregious error. The immigration judge analyzed the threat, which was a threat of death if she wore the cross or went to church again, along with what the immigration judge characterized as, quote, just kicking her, separately from the other violent incidents. But what we see here is a pattern of escalation, starting with outside of the church, going into another encounter on the street, and then escalating to a home invasion. When we look at many gang-related cases, they often involve mixed aims, forced recruitment, forced participation in a criminal enterprise like drug smuggling, forced sexual servitude. But here, what is the persecutor seeking to overcome? Is it kinship ties? Is it political opinion? Here, fortunately, we have it stated plainly. Plainly, it was religion. Eliminate the value system and control the individual. The IJ's finding that the threat did not rise to persecution because it did not come to fruition is, well, in addition to being insulting, I find it rather absurd. Again, because my client would not be alive. The immigration judge also said it was not an imminent threat because she was never threatened based on her affiliation with the Catholic Church thereafter. Again, not necessary under the case law of this circuit, but also legal error because the rest of the facts inform what happened during that first encounter. If we go back to the Tyro case versus Whitaker that Judge Floyd mentioned earlier, you had death threats at a public gathering, a single event, mind you. And then subsequently, there was a violent home invasion. Well, judges, that's exactly what happened here. You have a death threat that was made at a public gathering, followed by a violent home invasion. It all informs the same thing. It informs the credibility and the reality of this death threat made by a notorious criminal enterprise in the middle of one of the murder trials.
What's this thing called? Mara 18 or something?
Mara 18, yes.
And what is we supposed to understand that's a notorious criminal enterprise? Nobody bothered to explain that to us in these papers.
Yes.
And there's this another thing called 13.
MS-13.
MS-13, it's supposed to be one too. Are there others that are lurking around in these?
The 18th Street and MS-13 are the two most prominent gangs in El Salvador.
And we're supposed to know that by intuition or something?
I believe that in the administrative record at the immigration judge level, that previous council put in country condition documents
Maybe.
that discuss this.
Maybe I didn't get enough detail in the record, but I'm not, it's up to date on a lot of that kind of thing.
And what you hear, because one gang typically controls a particular area, you will often hear asylum seekers not be helpful on this point because they will simply say the gang, because the gang is one entity. That's not the case here. The asylum seeker knew exactly which gang it was and actually knew at least one of the gang members personally from childhood.
As I recall the record right, and I thought it was fascinating, after the third threat, like Valentine's Day or something, she left the country with her son the next day,
Yes.
February 15th.
It's also telling
And they
that
had to sell the cows to get money.
after attempting to do the right thing and report the fact that she had been victimized to the police basically did nothing at that point, and then she was threatened for going to the police. That was when she knew she would not receive any protection in her home country and had to flee.
What is necessary to establish religion as the central reason for an attack? You mentioned, alluded to the fact that maybe just that one incident alone might have been enough. And yet the cases you cite, there's not been one case that I found where it was just one incident. There were multiple incidents of the threats there. So when we face with one incident, I don't think we said per se that's enough, but are these other incidents necessary in order to conclude there's a credible threat that arises from religion?
Judge Wynn, I think it would depend on the record of each case, because I don't think if you look at a death threat in isolation without any other context, I don't think that the fact finder would have sufficient evidence to figure out whether it was credible or not. I think arguably the asylum seeker would not satisfy her burden of proof under that circumstance. So it is up to the asylum seeker, who has the burden of proof, to demonstrate the context of that death threat and establish its credibility. So there could only be one death threat. The threat of death constitutes persecution in the words of this court. But it can't be devoid of context. What the immigration judge's chief error here was robbing this incident of its context. In terms of religion here, there's a direct tie, because that's literally the words that were spoken by the gang member that issued the death threat. If they found her attending church again or wearing the cross again, they would kill her.
Thank you very much, sir.
Thank you.
And you have reserved a few minutes. I think Mr. Florino? I'm Fiorino. I'm sorry, sir. Good to have you with us. And you represent Mr. Attorney General Garland?
Yes, Your Honor. Paul Fiorino for the respondent. To address a point that was made between Judge King and counsel as to what the government's arguing in this case, we're not arguing for the court to change the law. Certainly we recognize that a three-judge panel can't change an en banc decision. What we would like the court to do is to apply the law as it's been written, and recognize that within the spectrum of harm that an asylum applicant can allege, not all of it equates to the level of persecution. And that's certainly what we're contending here with respect to the single death threat in the first incident outside the church. Now, it's true, as Judge King points out, that there were two subsequent death threats, and you made an allusion to Federal Rule of Evidence 404B, but as counsel pointed out, the rules of evidence don't apply. And for a very important reason in this case, is that for an act to constitute persecution, it has to have a nexus to a protected ground. And as the immigration judge correctly found with respect to the other 3 incidents of threats, that the religion of the respondent, the petitioner's religion played no part in that whatsoever. They had other motives. The one threat was directed towards retaliation for reporting the robbery to the police. The threats incurred in the robbery were motivated by pecuniary interest, and so on. So you can't, the immigration judge was correct in looking at the death threat, which for the sake of argument may have been the most severe form of harm here, in analyzing that particular incident as whether it constituted past persecution.
But there were 3 death threats.
Excuse me?
You said the death threat, that there were 3 death threats.
But only one of them had a nexus to a protected.
Well, she didn't go back to church. She didn't wear the cross. They didn't have to threaten her about going to church or wearing the cross. The next month or the month after that, she hadn't gone back to church. She said, I didn't go back. They said, if you go back to church or wear the cross, we'll kill you. And she complied. She complied.
Then one begs the question: why did they continue to threaten her? If she stopped going to church, did they have a continuing persecutory motive? And that's exactly the point here. That's exactly why the immigration judge didn't look at those other 3, because they made no mention of her church.
I thought it was, at least from the council side, that when he made in terms of the value, wanting to change value. And I assume there's a connection being made between one who is religious and goes to church and wears a crucifix, that they would have certain values, among which they're not going to just up and go and live with the gang leader and engage in a nefarious relationship with him. And it appears as though there's some incident, at least where they try to kiss her and indicate that they want her to come stay with them, that would indicate if we can get rid of her devotion in terms of religion, then that would serve the purpose. I'm not sure in terms of why would they want to accost her in the first instance, even before the robbery, in retaliation for telling the police, but there seems to be something else there. And the question is, does the whole record support that?
No, there is something else there, and there's no evidence that it's religion. There's no compelling evidence of any persecutory motive with respect to those subsequent threats. So that's why the immigration judge correctly looked at that one threat. Now, to get back to where I began,
I used to argue that when I was defending people in criminal cases, that should keep out the similar act evidence.
well, Your
And the
Honor,
judge never found a judge that would buy into it.
well, the reason is because
I would come up here to the Fourth Circuit, and they wouldn't buy into it either.
I'm sorry, I didn't mean to interrupt you, Your Honor, but the reason is
I plowed this furrow a few times myself, from both sides.
so. As I was saying,
And you say the evidence rules don't apply. They certainly give some advice to administrative law judges about what to consider and how to deal with evidence. I can't believe that the government would say the evidence rules don't apply. Well, sure, they may not be completely applicable, but if you got a question about some evidence, you refer to things like that. So that's where the law is.
Your Honor, if I may point the court to the law is immigration law. It's civil immigration law.
But these hearings are hearings.
It's different from criminal law, and the burden is on the.
Well, they are different than criminal law, and they're different than court. They're not court proceedings, but they're administrative law proceedings.
I understand Your Honor's position, but the case before us now is.
And this is the Attorney General of the United States that you're speaking for, and he's the one that they're working for too, the prosecutors.
Yes, Your Honor. As I was saying, This is a civil immigration case. Burden of proof is different.
But why are you up here arguing that we want to change, we should be changing the death threat law?
I'm not arguing that, Your Honor.
Yes, you are in your brief.
Well, to the extent that we said that in my brief, I'm clarifying, and I'm here to say
So you're clarifying now.
that
Go ahead.
the spectrum of harm.
That's a good idea.
The spectrum of harm involved in analyzing of persecution goes from one end to the other. There are levels of severity that the immigration judges and courts have analyzed and recognized, and that in this case, a single death threat is not sufficiently severe to constitute past persecution. And that,
So here's
that point is
the
informed
death
by-
threat that if you don't quit going to church, and if you ever wear the cross again, we're going to kill you. That's not enough, according to the Attorney General of the United States.
In this case, no. That's what we're arguing, Your Honor, because in the other cases where this court has found death threats to constitute persecution, there are other factors which increase the severity of the threat. In Hernandez-Avalos, there was murders that preceded the death threats, showing that the death threats were credible. In Bedoya, there was a murder that preceded the threat.
Your immigration judge found her credible. He credited everything she said.
Exactly.
Well, so what I said was what she said, and what the judge said is the fact. That's the fact of this case. It's not anything that you can impeach
Correct,
or
Your Honor.
question the validity of.
We're not.
It's this case. And the only thing you all argue, well, he didn't kill her. It didn't come to fruition. And maybe that proves it wasn't valid in your brief, which is
That's not
disjointed.
exactly the point that we're making, Your
Which
Honor.
is off the wall. It must not be a valid death threat because he didn't kill her. And her son, the 5-year-old boy.
The immigration judge made the finding of fact based on her assertion. He credited her assertion that
He
they
credited that statement
But that
that I
doesn't-
just gave you,
that doesn't end the immigration.
which is
judge's
makes that the
job.
facts of the case.
The immigration judge is required to analyze the facts under applicable asylum law and come to a determination as to whether that event constituted persecution.
What would have had to happen, what would be needed to satisfy past persecution in this case?
Well, for example, if there had been a credible death threat that had been carried out, such as in Bedoya, if they had held a gun to her head multiple times, as this court recognized in Hernandez-Avalos, other things, but just a single verbal death, or if there had been more death threats related to religion, multiple death threats related to religion. Those are the factors that would have tipped the scales. So what we're arguing here is not that the court should change the law. The court should apply the law as it has and other courts have done with respect to measuring and analyzing the extent of harm to determine whether it constitutes persecution. And one other thing I'd like the court to take notice of is the words of the petitioner herself on page 103 of the record. She was asked, "What are you afraid of from the gangs in the future?" And she said, I'm afraid that they're going to kill me in retaliation for reporting to the police." This was her chance. This is her evidence out of her sworn testimony as to how she perceived the harm that she faces. It had nothing to do with religion. It all had to do with retaliation and other criminal motives, which this court has held and other courts have held, doesn't constitute a persecutory motive. So to sum up, if there's no more questions from the panel, we would like to emphasize that there exists a range of harm that the court has to analyze, and the mere fact that it was a death threat doesn't end the inquiry The court, was the immigration judge, is still obligated to assess whether that harm rises to the level of persecution. And absent,
So a death threat is, you want us to rule that a death threat is not enough to establish persecution?
death threat, full stop, with nothing else, in this case, is not persecution.
And you said that would be, we would still be consistent with our precedent.
Yes, because the precedent involves analyzing the spectrum and level of harm, severity of harm, and so forth. And that is black letter law in asylum since the statute was.
Is there any, if we were to grant some relief to the petitioner here, is there any distinction that could be drawn between the three claims? Or is it a package deal?
I'm not sure I follow your question, Your Honor.
Well, they have three claims, don't they? Most asylum and CAT claims.
Well, I think that I don't think that the petitioner.
Well, there's three of them. There are three of them on appeal here. Three claims. I'll ask him that too.
Well, as I
I'm not trying to
understand
trap you
it,
into anything. I just wondered if it's a package or if it's up and down on all three, or whether we pick and choose.
if the court grants asylum, then its withholding of removal is obviated, okay? There's no need to consider withholding of removal. Convention Against Torture Protection is different. Convention Against Torture Protection requires a clear probability of torture, untethered to any nexus. It doesn't have to be on account of anything. As I understand it, and perhaps counsel can clarify, I don't know if CAT was, if I'm not confusing this with another case, I don't think in this case that the CAT was preserved. So
you're saying the CAT claim may not be on appeal?
correct.
It may not be here.
And
Okay.
if I'm mistaken, I apologize.
No. I don't know either. We got you fellas here to help us
Yeah,
out.
I've handled a number of cases.
You're here to help us.
Thank you. So, yes, if the court grants asylum, there's no need to consider withholding. The reason why the court would consider withholding and not asylum is if the petitioner was ineligible for asylum because of a criminal conviction or missing the filing deadline. The differences between the two is that asylum grants permanent legal status, which is a pathway to citizenship, whereas withholding of removal doesn't. The same is true with respect to CAT protection. CAT protection and withholding are mandatory, whereas asylum is discretionary. So that's the essential difference between two. So there's really, the court need, I think, make one ruling here, and I think that's asylum. And up or down on that pretty much determines the rest of it.
Thank you very much, sir.
Okay. Thank you very much, Your Honors.
Good to have you with us. Mr. McKinney?
Thank you again, Your Honors, and may it please the court. Very briefly, I want to point to areas in the administrative record where the asylum seeker declared why she thought she was being subjected to persecution. AR 7475. Ma'am, why did you come to the United States? Respondent in immigration court, petitioner here. Because of the church I attend, I was threatened that if I continue going to that church, I would be killed. 2 pages later, they just told me that if I went to church, they were going to kill me. 3 pages later, that if I returned to church or wore the medal, they would kill me. Then she described her involvement in the church. 20 pages later, she engaged in a discussion on why she believes that gangs don't like religious people. That's at AR 105 through 107. Going back to her affidavit, which was a couple of years before the individual hearing, she said, on February 13th, 2016, the same gang members who took my cross off and beat me up and intercepted me and my sister in the street and tried to force me to kiss them entered my house. Now, my client has very little education, and frankly, this declaration doesn't have the best syntax. But what she's clearly doing here is tying this up in its totality. Incident 1, gang members took off her cross, beat her up, threatened her with death. Incident 2, intercepted the asylum seeker and her sister in the street and tried to sexually assault them, forcing a kiss on them. Number 3, a violent home invasion. This is crystal clear. It checks every box of the asylum statute, but it speaks volumes to the government's continuing resistance to what is now the well-established precedent of this court.
Let me ask you something, Mr. McKinney. Why is it y'all wanted to bail out on your client? You wanted to withdraw from the case and not have it argued. I don't understand how you could do that.
No, I think that's entirely fair. And actually, we have finally made contact with our client.
I'm not talking about whether you could contact or not. It's not our problem. They don't have to be here for a appellate argument anyway. But that's between you and the client. But you wanted to withdraw from the case. You wanted to withdraw. I always thought lawyers take on a case, they stick with it.
I completely agree with that, Your Honor.
Maybe you hadn't. If they have a problem with getting paid, that's between you and the client. It's not for us.
Absolutely. I completely agree with that.
I had an old judge out there in West Virginia who used to talk about the missing witness, Mr. Green. These lawyers always come in and ask for continuances and withdrawal because they couldn't find the witness. And that we call that the missing witness motion. And the judges would deny it. But you came in and asked us to, at the last moment, to get out of the case, to withdraw from this 20-year-old woman and her son's case. And I didn't think much of that.
I apologize for that, Judge King. If you would permit me to explain, a lot of these cases, especially at this moment in our history, are resolved by having an open line of communication with the government, and we're often able to find resolution. Now, I could not find my client to even discuss a strategy with her. At that point, I felt that I was acting, I did not want to.
But you're a very able lawyer, and you could figure out the strategy. She wasn't going to be able to help you much. A 20-year-old woman from El Salvador, I don't think how she can be expected to strategize for an argument in a United States Court of Appeals.
Correct.
There, she's relying on you, and you're a good lawyer.
Thank you, Judge King. Look, I don't want to send the wrong message to this court. I've built my career on helping people like Ms. Sorto Guzman. It's not about fees. It's not about the money. It was about my ethics, not being able to even locate my client or know where she was to even talk about the case, that led me to make 3 motions, not just.
They were all in the alternative.
Correct. Just to be fair. But with that said, we made contact with her by email yesterday, and we're getting back on track. And thankfully, the court denied the motions. I'm happy to be here. Thank you for your time.
I appreciate your work, and I appreciate your help, and you also, Mr. Fiorino, and I apologize for mispronouncing your name. I've done that a lot over the years, mispronounce lawyers' names. I've done a lot of apologizing for that. But anyway, and if we could do so, we'd like to come to the well of the court and shake your hands and tradition of the Fourth Circuit and tell you did a good job. So we'll just tell you that from the bench, and hopefully you'll be back, and things will change by then, and we'll shake hands with you then. Thank you very much, and all the best to both of you. And Madam Clerk, Everyone situated? This is our fourth case of the day, number 216553, Wall versus Rasnick. And Mr. Martian, did I pronounce your name correctly?
Marson, Your Honor. Yes.
Martian, good to have you with us.
Thank you.
And you represent the plaintiffs.
That's correct, Mr. Wall.
You can take off mask right off. Yeah.
Thank you. May I proceed?
Go ahead. Yes, sir.
Thank you, and may it please the court. At its core, this case demands fair consideration of video evidence. The district court did not provide that consideration and instead committed multiple reversible errors. To start,
Multiple, tell me how many multiple is.
we identify, Your Honor, three critical issues in this.
Three reversible errors in your view.
That's right.
All right.
To start, Your Honor, the district court did not say a single word about the set of videos that were destroyed in violation of DOC's own preservation policy. And the district court then used the selectively preserved videos to form the basis for its dispositive factual findings on every claim and counterclaim in this case. With the court's permission, I would like to first address the spoliation issue and then briefly address the district court's factual findings on the claims and counterclaims and rest on the briefing regarding Officer Rasnick's failure to present sufficient evidence to prove his assault and battery counterclaims. To begin with the spoliation issue, Mr. Wall objected to the denial of sanctions, and he pointed to grievance documents that sought to preserve specific videos within days of the incident. These documents, after this serious incident.
Now, somebody wrote, the magistrate judge, I think it was, said that he hadn't asked for them to be preserved.
The magistrate judge, yes, Your Honor, found that Mr. Wall did not make timely, specific requests.
Is that another error of law? Is that another error that you're complaining of, or that's part of this?
I think that is an error, Your Honor. Before the court even gets to that error, the district court didn't say a word about that order, about spoliation, about Mr. Wall's objection.
Let me back up here. I've been talking too much this morning already, but both sides talk about a trial being conducted. How did we get to having a trial before a magistrate judge?
The magistrate judge referred to this as a bench trial, Your Honor.
A what?
The magistrate judge referred to it as a bench trial, I believe. I think the district court.
No, but magistrate judges don't conduct trials unless everybody consents. And wasn't handled as a verdict or anything. After the so-called trial was completed, there's a report and recommendations, which sounds like it's a regular referral with a report and recommendation on how to handle the case. But everybody talks about it being a trial, in which your client was representing himself, and the defendants were represented by what, the Attorney General?
Correct.
Of Virginia. But nobody explained how a magistrate judge is conducting a bench trial. Like, and this fellow Wall apparently called himself as the first witness, your client.
Yes.
He called himself. Did he cross-examine himself or examine himself? Do you know?
I'm sorry?
Did he examine himself?
He initially testified about the events that occurred. I will say he asked for the appointment of counsel on multiple occasions. Those requests were denied.
No, but he called himself as the first witness.
Yes.
Okay, so he was his own. Okay. Anyway, I don't understand this thing about a trial. You don't either, apparently.
Well, technically, Your Honor, when the district court referred this, I believe this was being treated as an evidentiary hearing. So calling it a
They didn't call it an evidentiary hearing, they called it a trial, a bench trial. And I don't know where in the code a magistrate judge has authority to conduct a bench trial unless it's been referred or consented to and waived and whatever you have to jump through to get a trial before a magistrate judge. They normally don't conduct trials, I don't think, but I'm not a lot of experience with that, but maybe. But here they talk about trial, but nobody explains how it came about. Nobody that I could find. And maybe it's in the details of the record that I didn't prowl into.
I don't know, Your Honor. I would point out, as you just said, Mr. Wall, or as you just referred to consent, Mr. Wall did not consent to a trial in front
Did he ever ask for a jury or anything like that?
He did not request a jury, and we are not raising an issue that there should have been a jury here. But we are raising issues regarding how the district.
But he was always pro se.
Yes.
Which meant he had to get some kind of liberal benefit or something of his papers.
Absolutely.
Go ahead.
And after this hearing or set of proceedings that the magistrate judge oversaw, the magistrate judge issued a discovery order denying any spoliation sanctions, saying Mr. Wall didn't make timely, specific preservation requests, and issued that report and recommendation. And Mr. Wall filed an objection both to the report and recommendation regarding the claims and counterclaims for relief.
Was he still pro se then?
Yes, he was. And in that objection, he also specifically objected to the denial of spoliation sanctions, the denial of ECF number 75 and 77, where ECF number 77 was his motion for spoliation sanctions. And the district court said nothing about spoliation or that objection. And that, Your Honor, that the court can stop right there and reverse and remand because the district court appeared to not even consider Mr. Wall's objection and the critical issue in this case of whether to impose sanctions. That's a violation of Federal Rule of Civil Procedure 72, which requires district courts to consider timely objections. And when a district court overlooks a critical issue like spoliation, that is a basis for reversal and remand for the district court in the first instance to address the spoliation issue. And we just don't have that.
Now, does the record support the proposition that certain videos were in fact destroyed? You said that earlier, that some were destroyed.
Yes, Your Honor, and I'll point the court to what the magistrate judge herself recognized on, this is coming from JA 1117 to 18, when the magistrate judge stated, someone did go in, look at this while it still existed, referring to the video evidence, and saved portions of it and didn't save all of it. And the defendants did not contest that below. And when we look at Mr. Wall filing the grievance documents he did, he started doing that within 5 days of this incident. Then he filed a regular grievance within 30 days. Those videos, according to the testimony of an intelligence officer, still existed up to 90 days after that incident. So he put everyone on notice by filing that with DOC that these videos were relevant to what anyone should have recognized, which was that there was a reasonable anticipation of litigation.
Well, as to the existing videos, are they enough to save Mr. Wall's Eighth Amendment claim?
The existing videos, if I'm understanding Your Honor's question correctly, if the existing videos are in the record,
Right.
does Mr. Wall still have an argument that there was reversible error on his Eighth Amendment claim?
Yes.
He does, Your Honor. And that that would allow me to talk about the second critical issue in the case, which is that when the district court did undertake fact-finding, unlike the spoliation issue, it clearly erred when it placed dispositive weight on that preserved video and an erroneous view of that preserved video. That goes for both Mr. Wall's Eighth Amendment claims as well as the counterclaims in this case the two defendants brought. If we look at JA 1326, when the district court provided its reasoning to provide judgment on the claims about the Alpha building and those counterclaims brought by the defendants, the district court found, and I'll quote here, that video evidence corroborates the officer's account, referring only to the preserved video. And then the court described its view of that video, and it added that based on this evidence, the magistrate judge correctly determined that Mr. Wall's version of events was not credible. That is clearly erroneous, Your Honor. The preserved video did not show much, and what it did show actually undermines the testimony, critical testimony, from the defendants in ways the district court never even mentioned. Take, for instance, Sergeant Large as one of those defendants. According to his account, Mr. Wall was swinging his fists and elbows before being pepper sprayed. And even after being pepper sprayed, Sergeant Large wrote in a report that Mr. Wall was striking staff with his fists. Even the little video we have does not show that behavior, even though it shows Mr. Wall's upper and lower body at various points in time. It was clearly erroneous then to find this video to be corroborative of the officers and to not mention these types of inconsistencies. On top of that, Your Honor, the district court actually used a lack of corroborating video evidence against Mr. Wall without applying the very same skepticism to the defendants when the video not only failed to corroborate their testimony, but contradicted their testimony. That's the type of unequal scrutiny that reflects a defective fact-finding process in this case on that second issue of Mr. Wall's own claims and the defendant's counterclaims, and how the district court clearly erred in granting judgment against Mr. Wall on all of those claims. I might just take a moment to say, too, that on the spoliation issue, that to use the lack of corroborating evidence against Mr. Wall in that way, again, just brings us back to the fact that Mr. Wall, within 5 days of this incident, and I think this goes to his credibility, told everyone, look at these videos.
What remedy are you seeking for what you say is the failure to consider this spoliation sanction motion?
This court should reverse the district court's final order and remand to the district court with instructions to consider the spoliation issue and the possibility as well, given all of the flaws we've pointed out in the magistrate judge's order in the record.
And who would that affect? Would it affect all of the defendants or only those involved in the escort?
It would affect all of the defendants, Your Honor, not just those involved in the escort.
Why is that so?
That is so, Your Honor, because the sanctions Mr. Wall sought, the videos that he sought, went to the credibility of all of the defendants in this case, including the ones who were involved in the altercation in the Alpha building. And no defendant, not even the ones involved in that altercation, came forward here and provided any reason or explanation for why there shouldn't be a sanction against them. They never explained if they knew about these videos or didn't know about the videos. And the videos that even showed the escort, Your Honor, those videos would have shown Mr. Wall's condition as he was taken out of the Alpha building. Those officers in the Alpha building testified that they didn't see Mr. Wall lose consciousness. We point to even the existing video that shows Mr. Wall is being carried horizontally out of that building, and those cameras outside could have captured that as well.
Can we, or should we treat the district court silence as an implied denial?
This court should not do that. The reason why, Your Honor, is the district court itself, when it referred to objections being filed in this case, said that Mr. Wall has filed objections to the R&R, the report and recommendation. It looks like the district court just missed entirely and didn't consider at all the objection. And so I don't think that there's a reason provided by defendants here for this court to deem the district court to have considered the issue when it was so important, went to the heart of the case, and we don't even have a mention of the objection. Even if the court were to consider it, though, I think that just brings us to the flaws in the magistrate judge's order. And as I was responding earlier, when the magistrate judge found that the video evidence that Mr. Wall requested was preserved and presented at trial, and that Mr. Wall did not provide timely, specific requests that the defendants preserve additional video evidence, that's a clear error that tainted the entire analysis that's even in that magistrate judge's order.
What segment of the video supports you the most?
The most, Your Honor, I might come back to the Sergeant Large testifying that Mr. Wall was swinging his fists and elbows before being pepper sprayed. I think from that A123 vestibule video, we can see that before that officer, that sergeant, entered the pod, Mr. Wall was face down with his left arm behind his back. I think that's quite supportive of Mr. Wall's testimony. If I could give one more example, I would point to the fact, and the district court didn't say a word about this either, even though Mr. Wall brought it up at trial. There's a moment in that video when an officer's arm rears back and goes toward Mr. Wall in a punching motion, which is corroborative of Mr. Wall's testimony that he was attacked and that he was not in any way attacking or resisting these officers.
How much time-wise is missing video is there?
I don't know an amount of time. The video that's missing starts with the recreation yards that were outside the Alpha building. It continues into the Bravo building, and it includes a vestibule video that was in that Bravo building where Mr. Wall was being held against a wall. And it even includes a camera cell, that's what defendants called it, where Mr. Wall was held for hours after the incident.
So you can't tell us how much missing video there is?
Not a precise amount of...
Well, is there a range?
Mr. Wall, in his grievance documents, he pointed to a 1 hour range between 4 and 5 p.m.
That the 1 hour of video missing?
That's what he first referred to.
He's referred to that.
That's right.
And is that the other side offered an estimate? Is there anything else in the record about the amount of time?
I would point to that we know Mr. Wall was in that camera cell for a matter of hours. He was taken out of the camera cell around 7:30 p.m. I think he was placed in there sometime before 4:30 p.m. So that's the additional amount of time that footage in that cell could have captured with what his condition was when he was in that cell.
And what's the permissible remedy for spoliation of evidence if these videos were destroyed intentionally, knowing that they had been requested or knowing that they contained something adverse to the defendants?
Knowing that they contain something adverse to the defendants and trying to prevent Mr. Wall from being able to use them, an adverse inference against each of the defendants would be a permissible sanction.
Adverse inference to be considered by who? The magistrate judge in this so-called bench trial, the district judge in reviewing the report and recommendations? What?
Both the magistrate judge and the district court. Ultimately, if this court views what happened as an evidentiary hearing where the district court de novo had to make all the factual determinations, the district court would be the one to impose that adverse inference.
But the district court didn't hear any of the evidence. That was all I was just heard by the magistrate.
Correct.
The district court acted on that report from the so-called bench trial.
That's right.
Okay. Thank you.
Thank you.
Let's see now. Ms. O'Shea?
Yes, good afternoon, Your Honors. Margaret O'Shea from the Office of the Attorney General on behalf of the appellees. The defendants recognized at the outset of this case that it was really going to rise and fall on the credibility of the witnesses. And that is why, rather than submitting a motion for summary judgment or other dispositive pleadings, we elected to take this case to, we call it a trial, it's actually an evidentiary hearing on referral.
How did that comport with the statutory authority of a magistrate judge?
Under the Magistrate Referral Act, a federal district court judge can refer an issue, a motion, or anything in the case to a magistrate to conduct an evidentiary hearing and present proposed.
Why wasn't this called that kind of a thing rather than a bench trial?
It should be called an evidentiary hearing technically, and that's what's referred to in the order of referral, which appears at JA 90.
JA 90?
JA 90, yes. It's the order of referral signed by the district court judge, referring things to the magistrate judge to take evidence.
Was that made by Judge Kaiser?
Yes, sir.
That's what I thought.
Yes.
So that's what you're relying on?
Correct. And it is commonplace in the Western District for the district court judges to refer hearings to the magistrate judges who conduct, it's a bench trial-like setting where they take evidence from the witnesses. The magistrate judges present their findings and their credibility recommendations to the district court judge. The district court judge reviews it de novo and has the option to accept the credibility findings of the magistrate, rule on any objections to the report and recommendation, and reach a final disposition. If the magistrate judge does not like the credibility decisions or disagrees with the credibility decisions of the magistrate, the district court judge retains the authority and in fact should, under the Raddatz case, I believe it is, a U.S. Supreme Court case, convene a new evidentiary hearing to hear the live testimony of the witnesses for itself before then going further and issuing a final disposition in the case. In this particular case, the district court judge, reviewing the body of evidence before the court, agreed with the credibility determinations of the magistrate judge, saw no reason to overturn any of those credibility findings, and enter judgment on behalf of all of the defendants. That decision is supported by ample evidence in the record. This was a 2-day evidentiary hearing, 14 witnesses, 42 exhibits.
How many days?
2 days.
2 days.
Yes, sir. And it was an enormous body of evidence that was considered by the magistrate.
Now, the Mr. Wall was representing himself.
He did.
Was he present?
Yes.
Was this in the courtroom down at Abington? Or Big Stone Gap?
Yes, sir.
You went out to Big Stone Gap?
Yes, sir.
And Mr. Wall was present, and the defendants were represented by the Attorney General of Virginia?
Correct. Yes, sir. The findings of the magistrate judge, the credibility determinations, the recommendations, and the district court judge's rulings on those and decision to adopt the findings of the magistrate judge were supported by more than ample evidence in the record. And this court has to look at those findings and that evidence through the appropriate deferential standard of review, which is in the light most favorable to the parties prevailing below and with due deference to the credibility determinations of the.
Who was the party prevailing below?
It was the defendant correctional officers.
Before the magistrate?
And before the district court judge, yes, sir.
Oh, you're talking about us reviewing it. I thought you were talking about the district court's review.
No, sir.
All right,
I'm saying in this court, it's standard, it's part of, appellate canon, right? That
Yeah,
appellate court
right.
judges don't decide what you would have done in the first instance. You look for clear error in the lower court's judgment, and that clear error just doesn't exist here. I would like to talk first a little bit about the spoliation ruling. We go through the reasons in our brief as to why we believe it's procedurally defaulted, but bottom line on that, if you're going to argue something on appeal.
Assume it's not procedurally defaulted.
Yes. If it's not procedurally defaulted, if the court gets to the merits, because Mr. Wall did not sustain.
He's pro se, and he asked them to preserve the stuff.
He asked them to review it, but he didn't ask the defendants to review it. He sent in an informal complaint that was reviewed by a non-party and responded to by a non-party. There's no evidence that any of the 11 defendants specific to this claim, or actually any of the defendants, were made aware of that informal complaint or its contents. To prove spoliation, you have to show that a party, the plain language of Rule 37E is a party, had a duty to preserve evidence within his control, neglected to do so, and the loss of that evidence caused prejudice to the party complaining about the missing evidence. It's multiple layers there. Mr. Wall did not carry his burden under any standard of review of establishing each and every one of those elements. He didn't show that there was a party with a duty to preserve that failed to adhere to that duty. He talked generally before the magistrate judge about whether the Department of Corrections had a duty to preserve, and that's the argument that's been presented by the other side.
Well, that's what it would be. Wouldn't it be the duty of the Department of Corrections?
Well, the Department of Corrections is not a party. Rule 37E requires a party. And I would also note the advisory committee notes make clear that just because an entity might have an independent obligation to preserve under its own policies or rules, that's not the same thing as whether there's a pre-litigation duty to preserve within the meaning of Rule 37.
Of course, we're arguing it almost like it's de novo, but the district court didn't deal with it.
The magistrate judge did, yes, Your Honor.
The magistrate judge did in a report and recommendation, but the district court didn't.
And
it was supposed to be reviewing it de novo.
no,
What?
because this was a referral of a non-dispositive discovery motion that gets reviewed for clear error by the magistrate judge under Rule 72B.
Okay.
It's not a report and recommendation that's reviewed de novo under Rule 72A.
So you're saying the district court didn't have to even mention the spoliation objection?
I'm saying, one, the district court judge didn't mention the spoliation objection because it wasn't properly presented.
You
to the
didn't answer
district court
Judge Wynn's question.
And then I'm saying, second, no, the district court judge doesn't explicitly say in its opinion, I'm ruling on the objection for purposes of appellate review, that Mr. Wall stuck at the end of his objections to the report and recommendation, but the district court judge does say, I've reviewed that filing and I found 4 objections that are specific enough for me to address.
So you have the spoliation objection. He doesn't address that at all, but you said the issue in this case is credibility, and it would seem to highlight the importance of having the video, some of which was not preserved.
Important to both sides, Your Honor, which goes to the magistrate judge's unchallenged finding that there was no destruction of the evidence for the purpose of preventing its use in litigation. That is a specific finding that needs to be made before you can apply an adverse inference sanction against a party in litigation. There is no presumption of prejudice to either party that arises from the absence of evidence.
How much video do you say is missing? State.
Well,
How much does the state say is missing?
So it depends, Your Honor, on the type of evidence that they're talking about. The escort from one building to another building within the prison, that's a matter of minutes. I can't say exactly how many because we don't have it clocked or logged, but that would probably be a matter of minutes. You could, or I could, probably go through the control booth logbook entries that are part of the evidence and note when it says that Mr. Wall entered the building, left one building, and entered the other building, and that would give you a timing estimate. So it was a few minutes of the escort. And then he claimed, if I recall correctly, that there were a few minutes when he was brought into the new building that weren't recorded on the surveillance video before the handheld video, which we do have, started. So it's a few more minutes there. If he is also claiming that he's entitled to the surveillance video, notwithstanding the presence of the handheld video, from the time that he arrived in the B building until he was taken to the camera cell, that's probably maybe 10 minutes or so. And then after he gets taken to the cell and the restraints are put on, if he's claiming that he needs the video from that, that's going to be...
You tell me what he's claiming. I was asking you what you all acknowledge is missing.
So I acknowledge that surveillance video would have likely captured some aspect of those various parts of Mr. Wall's movement within the prison. What I would like to emphasize, though, is that absent a showing of willful intent to destroy, to prevent the use of this video evidence in litigation, you can't get to an adverse inference type sanction. And that's the only thing that Mr. Wall asked for, really, apart from default judgment, which is even higher, depriving the defendants of the ability to defend their claims, same thing.
Well, it seems to be a question when you're dealing with, when you say credibility is the big deal, and then you have a video, as to whether there's an adverse inference that you can make. I mean, what is this video for? As I recall, I think in the record, and correct me if I'm wrong, the magistrate judge did mention that somebody certainly had to notice that that he wanted these videos.
Yes, but someone is.
So
not.
who was he supposed to ask for the videos if not the prison?
So it is the prison, but again, this goes back to who at the prison had knowledge that Mr. Wall might be raising these claims at a subsequent
Well,
date.
he's in prison, and presumably a prisoner doesn't have free rein to go around and ask who he wants to ask. He typically they have rules, pretty strict rules in terms of who you can ask.
Correct.
And you would think if he maintains all of this that happened, and as you say, his credibility, and he says, want the videos. But it seems like to me, everybody would quickly realize the videos is what you want. Let me ask you this. Even the video that was not preserved, did anybody ever see it?
That's not clear on the record, sir.
I'm asking you the question. To your knowledge, did anybody ever see it? Let me put something that's in the record. Is there anything in the record to say they didn't see it?
The evidence is not clear, and I'll explain why I'm not trying to avoid your
That's
question.
okay.
The intel officer, intelligence officer Bentley, testified at trial. He was asked, what is standard when you get an informal complaint? Like, so what are you supposed to do? Officer Bentley said, well, you're supposed to look at the informal complaint, look at the video that corresponds to it, save anything important.
Common sense tells you that. Kind of, if you got an altercation and you see a video, that's like if you see someone rob a store and they say they got a video out there. It seems to me you go take a look at that video for a lot of reasons. And so what you've just said is that the general policy is you would go look at the video.
Correct.
So is there anything in the record to say they did not look at the video in accordance with what common sense would say you would do?
Again, Investigator Bentley is the one who responded to the informal complaint, and he said he just couldn't remember. So he couldn't remember.
But he can remember what he would think ordinarily an officer who is thinking straight would do, and that is there's nothing to indicate he did not see it.
Correct.
And so you would, if he saw it and there's something that potentially could help one way or the other, you would think that would give rise to preserve it.
You would think, Your Honor, but also I'm aware, and I believe that Intelligence Officer Bentley testified to this as well, is back then, we're talking a good 7 years ago, I think, the Department of Corrections would look at the videos, and if they didn't actually show anything, they wouldn't save them. That practice has been changed now as litigation has evolved.
Well, that leads to another question. I mean, they preserve some of them. And so then the question is, why did you preserve some and not others, particularly in the face of what's going on here? It certainly gives you some indication that maybe that was intentional, whether it was or was not. But, it's like the Nixon tape. If you missed a few minutes there, you wonder what was on that tape. Of course, I assume we'll never know that answer, and I don't want to go there. But it doesn't sound like we're going to know this answer either as to what's on those tapes, because they're destroyed, right?
We'll record it over in the ordinary course of business, but yes, sir, they're not available.
And there's no technology in recording. At least the young folks tell me that nothing is destroyed, at least in the digital world. I don't know how the tapes work, but if you record over tape, that doesn't necessarily mean it's gone. It may not be able to be retrieved. You have the technology to do it, is what you're saying.
That's correct. It's not retrievable after it's been written over.
Is that in the record?
Yes.
Was there part of this so-called trial that was directed to a determination of the missing videos? And the spoliation question of how it came to be missing and what happened to it?
So it's kind of interwoven throughout the testimony because
It was not. There was not a focus on, did everybody that had anything to do with maintenance of these things get on the witness stand and testify?
No, sir.
Well, then we could ask for a full-blown hearing to determine what happened to the record, to the video,
So the pre-trial
get to the bottom of this thing.
the pretrial discovery motion had been referred to Judge Sargent for disposition along with the evidentiary hearing. It was the opportunity of both sides to present evidence on videos, missing videos, and so on and so forth. Mr. Wall, as the party seeking spoliation sanctions, he's the party who had the burden.
He's the pro se fella. You know, you all, and you talked about these, them filing objections late and didn't calculate right yourself. The Attorney General's office didn't allow for the mailing time that they found on you. He's the pro se plaintiff until Georgetown got into it. He gets the benefit of liberal construction of things, allegations and application of rules and all that stuff.
I understand that, but as the party who bore the burden of proof.
And he's up against the Attorney General of Virginia and a group of lawyers from the Attorney General's office.
Just
In a so-called bench trial, which wasn't a bench trial, as you're saying now. Anyway,
but our position.
maybe there ought to be a hearing just to try to figure out what happened to the destroyed videos and how it happened. And so maybe they could retrieve some of them, get some experts and see if they could dig these things out, see if anything can be preserved, ascertained.
Isn't that about the furthest we could go with this? If, in terms of the remedy, if there is a remedy, we found, okay, there should have been more done. Basically, it seems to me what's being asked is, you know, beyond the sanction. It's not saying go ahead and hear the sanction. It is to go back and go through the procedures and make that full determination as to whether this motion should be granted or not.
Yeah, they say the judge, district judge didn't rule on spoliation. Well, he didn't have the information because he didn't have the benefit of a full-blown hearing before the magistrate to figure out what happened to everything.
He had the testimony from the intelligence officer who testified about the procedures. He had testimony from Mr. Wall about what Mr. Wall said he did that he thought was sufficient.
He wasn't, Mr. Wall had anything to do with making the videos. He was the one that was on this receiving end, part of it, or on the giving end, from your standpoint. He was involved in it.
Yes, sir. But pro se or not, he bore the burden of showing a party allowed the destruction of evidence with the intent to deprive the other side of its use in litigation, and that evidence just wasn't there. And he had the opportunity to ask all of the defendants about that particular issue, and he did not. The magistrate judge found as a factual matter, this evidence was not lost because somebody wanted to keep it out of Mr. Wall's hands. That is what was required to be shown in order to get to the adverse.
But you just basically told us earlier that not everybody testified about that particular issue, that the facts weren't ascertained.
But Mr. Wall had the opportunity to ask them about that and did not. Bottom line, the question of whether or not Mr. Wall should have been represented by counsel, that's not an issue that's been raised on appeal. It's not before the court. This is a civil case. He was proceeding.
He's got counsel now.
He does now.
He's got the Georgetown litigation clinic.
Absolutely. But to get to a finding of prejudice, the only prejudice he argued is that video would have supported my version of events. So in order to apply the sanction to cure
Well, that would be the thing to find out, because you had a counterclaim that they granted relief on,
Right,
to make sure that we know what the facts are. If there's an adverse inference to be drawn, that the counterclaim judgment's probably flawed.
I disagree because the counterclaim preceded in time. The counterclaim pertains only to events within the housing unit for which there is retained video. So the loss of evidence has nothing to do with the counterclaims. But I would take...
Well, we're not in a position to agree with you or not, because we don't have the record. You didn't have a full-blown hearing about the loss of evidence or destroyed evidence.
You know, the whole instance of the credibility, as I understand, Mr. Wall said he felt unconscious. But then the officer said, oh, no, he was conscious and resisting the entire time. Well, there is a video in this thing, and it shows him Mr. Wall being carried. He has his hands and feet up in the air, and his head is parallel to the floor. I don't know what he is, but it doesn't look like to me he's doing any resisting in this video. And I'm only just saying that video evidence looks like it's pretty important in terms of credibility, because here you have an instance where that video that's being shown, and of course the district court, they don't mention this, but that's the problem when you send videos up here. You take a look at them, and because it's part of the record, and you say, wait a minute, this guy doesn't look like he's resisting. If you're looking at the testimony and screaming and kicking or whatever, or conscious, it's like he's out. That's what it looked like. I'm not saying what he is, but I'm saying, but that only goes to say that when you're measuring credibility, that gives you more of a pause and says, you need to conduct that full-blown hearing that Judge King is talking about with regard to the ones that you didn't preserve.
My time has expired. May I respond to Your Honor briefly?
As long as you get questions, you keep answering.
Yes, I don't want to tread on anybody's toes. So I agree, but I would also say, Your Honor, that the evidence that was preserved from the video, from the housing unit, Mr. Wall testified, well, I was there, hands out, not doing anything at all. They took me to the ground, and then they started punching me in the head. They were kicking me in the head while I lay there unconscious. That didn't happen at all. If that had happened, you absolutely would have seen officers up and kicking him in the head. There's no way that wouldn't have been captured by that surveillance video in the housing unit.
Well, it's sort of like a jury thing. You got some evidence from the video is going to support his version, but I'm saying here's something here that support Mr. Wall's version. So it goes to that credibility thing that seems to be so clear until you look at it and says, wait a minute, these guys aren't exactly telling it as it looks on the video either. And again, I'm not going to try to make that determination of whether it happened or not, but I'm just saying that that these videos are supporting there's a credibility problem. And when you know there is a segment that he maintains is fairly crucial, I don't know what it would show, and it's gone. And you wonder why you have these and why you don't have this. He made a request, and why did you preserve these? I guess because he made a request, and all of these are the ones he made the request for. It really calls into question, at least somebody ought to ask some more questions.
Oh, I understand Your Honor's position. I would say the part of the video evidence that you're referring to is after he's been taken out of the housing unit. He's plainly bent over. There's an officer who actually has his hand on his neck, helping hold him down, not holding him up. The magistrate,
his hands and feet are up in the air as you're going. I mean, the video speaks for itself. I mean, we probably can describe it all day long, but it's there.
and that kind of goes to the credibility determination.
But we don't have all the video. But you're talking about the video, but we don't have all the video. Our lawyer from Georgetown says there's more than an hour missing.
But it's not just the video that the magistrate judge and then the district court judge considered when deciding who to believe here. The magistrate judge listened to Mr. Wall.
But we don't know what's on the missing video. We don't know what happened to the missing video.
But the magistrate judge considered the demeanor.
And missing videos, like missing tapes, are suspect circumstances.
But only if there's an intent to deprive. The advisory specifically say.
That's what the hearing would have to develop.
Information lost through negligence alone may have been favorable to either
It could be all negligence, that's
including
right.
the party that lost it, which is
Could
why we
be.
only have a negligent loss of information.
could be.
You cannot impose an adverse inference. You
Yeah.
cannot impose a presumption of prejudice, and that's exactly what Mr. Wall's asking for. It's not available to him because the underlying factual circumstances aren't there. No party to this case intentionally destroyed or allowed the destruction of evidence within their control for the purpose of depriving its use in litigation. So we don't know what the video would show, but we do know things that Mr. Wall testified to that rung hollow with the magistrate judge, and she determined basically that he was lying. And that was well within her discretion. She heard him testify, she heard the officers testify, and ultimately it was her call, her decision, that he wasn't telling the truth. On a clear error review to this court, which is what we have, that is not reversible error.
Of course, that was never ruled on by the district court.
Because
you're telling us all this stuff.
that objection was ruled on by the district court judge. The only thing that
The
wasn't...
spoliation was not ruled on.
Correct, because.
I was taking the chance, exactly what you were talking about was the spoliation.
So I was talking about the overall credibility.
But the spoliation relates to the credibility, is what they argue right there now.
And I take a slightly different position that I think that the spoliation only pertains to the excessive force bystander liability claims of the 11 defendants involved in that escort.
Who does the grievance run to?
It goes to the intelligence officer who testified at trial. Oh, I'm sorry. Did you mean the informal complaint or the regular grievance?
I don't know the difference.
The informal. Sorry, the informal.
You're asking me questions. I get to answer I get to ask the question.
Just want to make sure I'm
Just
answering.
make that pretty clear. I ask them.
The informal complaint where Mr. Wall said the excessive force continued while I was being taken from one housing unit to the other. Check out these videos. That goes to an intelligence officer. It didn't go to any of the defendants.
An intelligence officer works for the Department of Corrections.
He does.
That's right.
And I just,
He's the, yep.
I don't want to
All right.
pass my time.
We've given you 5 extra minutes, and now Mr. Marchin.
All right. Thank you, Your Honor.
We should be calling you Professor?
Mr. Marson is fine, Your Honor.
You teach up at Georgetown, do you? Don't you?
I'm a fellow with Professor Hashimoto in the clinic.
We really appreciate y'all's work, but you go right ahead with your rebuttal.
Thank you, Your Honor. Just a few quick points on rebuttal. I'd like to start with what Mr. Wall did. Judge King, you asked at the beginning of the questioning of my friend on the other side if Mr. Wall asked to preserve these videos. And my friend said that Mr. Wall asked for review of the videos, if I heard correctly. If the court looks at JA 116, it'll see that all Mr. Wall had to do to trigger DOC's preservation policy was reference these videos, and he did that.
And that's the policy, JA 116?
JA 116 includes changes to the policy which implemented this key provision. Mr. Wall also included the full policy with his objection as well. And so that triggered the duty to preserve, and we know that someone went in, as the magistrate judge said, someone went in, looked at this while it still existed, and some was saved and some was destroyed. That takes me then to questions that the court has had about the remedy for the district court's silence and the failure to even consider this critical issue. A full-blown hearing, a full-blown inquiry should happen, Your Honor. It should have happened to begin with. And I think that that is something that should happen on remand. My friend on the other side said that Mr. Wall, had the chance to ask questions of that intelligence officer, for instance, who was called to testify. I just want to point out that Mr. Wall identified the policy I just referred to the court and asked that intelligence officer about the policy and whether Mr. Wall referencing footage required that the video was to be saved. And the officer answered on JA 802, I'm not positive on that, but once I turn over the incident to the Special Investigation Unit, I'm actually assisting them with the investigation.
What do you do with the opposing counsel's argument that the spoliation issue must be done by one of the parties?
This answer by this intelligence officer, Your Honor, shows why that's a bright line rule that has not been the common law, that is not in Rule 37, and that would create a dangerous incentive, as other courts have recognized, because it would put the burden on adversely affected parties like Mr. Wall to pinpoint the exact party who was responsible for the destruction that everybody agrees happened, everybody agreed in front of the magistrate judge happened, and that individual party, even when that party has a special relationship with the Department of Corrections, and that Department of Corrections destroys the evidence, that would allow no sanctions in that case because the department was the one to destroy the evidence. And that would create an incentive, as courts have recognized, for departments of corrections to destroy videos, to spread the responsibility over controlling them throughout an institution without facing any repercussion in a Section 1983 suit.
Speak to the evidence of prejudice sufficient to warrant an adverse inference.
I'll start with adverse inference, Your Honor, by saying that we have selectivity here. We have a conscious choice to save some videos and let others be destroyed. This wasn't a routine business practice that led to all of them being saved or all of them being destroyed. And with that selectivity, we have two other facts. One, that there was a breach of DOC policy here, that policy Mr. Wall cited himself. And two, even the magistrate judge recognized this was a recurring issue at DOC. That's circumstantial evidence that there's an intent to deprive him of evidence at trial here. But I want to point out with Your Honor's question as well, because my friend on the other side talked a lot about bad faith and an adverse inference. That's not the only sanction that's available here. District courts have a lot of discretion that Rule 37 provides them. And another sanction, even short of an adverse inference, would have had a dramatic effect on this case. The district court could have considered the circumstances surrounding the destruction of these videos when making its ultimate factual findings. And it could have done two things even short of an adverse inference. It first could have said that it's not going to use the curated videos to credit the officers because of the circumstances of the destruction of others. And it second could have said that it's not going to use the absence of video evidence against Mr. Wall because he was trying to corroborate his testimony from day one. So those are other sanctions that are available on remand as well.
What's the remedy that you want?
A reversal, Your Honor, of all of the final order and its ruling on all the claims and counterclaims, and a remand for the district court to, one, conduct a proper spoliation analysis, including a full-blown inquiry, as Your Honor referred to earlier. Two, to undertake a reasoned fact-finding process when it comes to the actual claims and counterclaims in this case. Not to do what the district court did before, which is to put all the weight on an erroneous view of the preserved videos. And all I would add, Your Honor, just because I rested on the briefs earlier, but we're also seeking outright reversal and for this court to order the entry of judgment against Officer Raznick because he did not even present sufficient evidence for his assault and battery counterclaims. And I see that I'm over my time.
No, I just wanted to give you time to tell us what you want.
I think the only thing that I would add, Your Honor, to the questions about whether this was a bench trial or an evidentiary hearing, part of what can and should happen on remand at a hearing is that the district court can hear from witnesses and can make reasoned credibility determinations, unlike the clearly erroneous ones that we have right now.
So you don't say there's any difference between an evidentiary hearing and a bench trial?
I think there is a difference in terms of...
Well, go ahead.
Sorry, Your Honor. I think at a bench trial, when I think of a bench trial, there's no de novo review by a district court.
Well, bench trial, the judge renders the verdict.
Right.
You don't have any findings of fact, recommendations or reports about findings. You have a verdict. I mean, you can call them a findings of fact and conclusions of law, but after a bench trial, there's a verdict rendered by the judge. That's conclusive. Well, it's the way I've always understood it anyway. But what I want to say is we really appreciate the work of the Georgetown Litigation Clinic, if that's the right name, Appellate Litigation Program, Georgetown University Law Center. We really appreciate what y'all done and we commend you for it. And what are y'all going to do if we would send it back under your request for a hearing? Are you going to abandon your client or are you going to stick with your client?
We're an appellate litigation clinic, Your Honor, but what I can say is that we are committed to try and find trial counsel for Mr. Wall.
But you're not committed to stick with him?
I can't speak for the clinic's capacity to take on a trial, but I certainly would say that the clinic will take seriously and will endeavor to find trial counsel for Mr. Wall to make sure that he is not continuing to proceed pro se.
You all didn't hear in the earlier case we had here today that you weren't present for. I chastised the lawyer a little bit for threatening to abandon his client, basically, withdraw from the case. And I never liked that from lawyers. they get in a case, I always thought they stick with it. That's the way we practice law where I came from. Anyway,
Well, I would agree with Judge King in the fullness of an educational experience. To not be involved in the trial of this and to do here is a bit different than the firms who do primarily nothing but appellate litigation. I mean, there's an experience here. And to talk about it, I will tell you, I know being an appellate lawyer is an art and is totally different, but if you've actually been out there trying the cases, there's an input that you bring to the experience that you really can't get just reading the records and briefs. You got to know what you're talking about. To have actually been in that court, as you probably heard Judge King allude to several times here of his experiences, and said being on both sides of that quarrel. But anyway.
Absolutely. Thank you.
we appreciate what y'all done. We appreciate the Attorney General's office work as well. And we'll take the matter under advisement. If we, and I tell the Georgetown folks, if the Fourth Circuit, when we conclude arguments, it's a general matter, we come down and recounsel, the judges do, and we briefly talk to you and introduce ourselves. We can't do that because of the pandemic and the way we're handling that. But next time, we hope to be able to do that. And with that, Madam Clerk, we'll adjourn court until 9:30 tomorrow morning.